Yes. Item number 37, madam. I would like to, madam, to withdraw this petition on instruction, madam, that become infraction.
The summary of the Learning Council appearing on behalf of, submits that the petition had become infructuous, and as such, the petitioner would like to proceed with the petition. Taking into account the above, the petition stands closed as it had become infructuous. Interim orders, if any, stands vacated.
I'd like to mention item 51 of today's. 51.
Yes.
With the consent of the petitioner, I would like to pray that the matter may be considered after the vacation.
The request of Mr. S. Purva appearing for the Pollution Control Board matter stands adjourned to be listed after 6 weeks.
Victim is item 55. In this case, I have filed an IA for stacking of the name of the respondent number 4. That is not listed. Can it be taken up along with the IA, my lord? Yes. On reopening, my lord.
You have filed an IA.
IA for stacking of the name of respondent number 4.
I circular. The learned cow. You are not nobody as of now in the matter.
So, well, I'm here in this case.
You have filed, but as of now you have not. Are you appearing? Your name doesn't appear anywhere.
In the Okalat number, I signed, but in the Rosnis, my name is not so.
Then
Okalat number signed by me.
counsel appearing on behalf of the respondent number 4, Mr. I cycle 6 for an accommodation. List the matter after 6 weeks.
Along with the IA.
You come, you take it up with the registry.
Okay.
State user lordship, with due consent from the other side, I would like to mention item number 5 on behalf of Ms. Arbora, Standing Council NHA. Actually, your lordship, she is down with high fever, cough and cold. Lordship, if I may pray that the matter may be taken up on this Friday. Lordship, by that time, I think she'll be all right, lordship.
The request of Mrs. Arbora, SC NHAI. The matter will be listed after notifications.
Highly okay.
May I please, of course. Also, I beg to mention item number 30, 42 and 45. On instruction, your lordship, I may allow to withdraw this for the
30,
30, 42 and 45.
SK Akan. The people withdraw.
So, lordship.
Next is your lordship. Lordship in item number 3 and 4, lordship, an affidavit has been filed on behalf of respondent number 11. Lordship, the record may kindly be called.
Right, Mr. Lordship. No, sir, with the consent of the other side, I would like to mention item number 50 of today's list, sir. With the prayer to, can we take up the matter after the petition also? Item
After?
50.
Counsel appearing on behalf of Mr. CKS Bulwa appearing on behalf of the respondent 6 for an accommodation. List the matter after 6 weeks.
You will list the matter on 8th of January.
6 weeks. No dates.
No, sorry. Possible, sir.
It may be taken after vacation or lordship.
44.
Yes, your lordship.
The request of Miss
Please, Soren.
and the learned counsel appearing on behalf of the petitioner. Petitioner? Matter stands adjourned to be listed after 6 weeks.
Thank you, lordship. I beg to mention item number 32, lordship. Finally, this matter may be adjourned for the day after 2 weeks, lordship. This matter was taken, lordship. The government filed.
Your name?
B. Ulaskar, lordship.
Mr. B. Ulosko submits that he picks for an accommodation. List the matter after 6 weeks.
May I please, your lordship. But I have already filed the affidavit stating that
Now, tell me, Mr. Roy, is it possible to give a compulsory retirement backdated?
Yes, sir. Because in lieu of revision and because there is an order not to dismiss and remove from service, in lieu of that, compulsory
Understood. But can you make it backdated?
that cannot,
That is what, no?
that can. Because it is the last patient lordship is saying.
If you cannot backdate it, then obviously he will be entitled from that date. The compulsory retirement here. Show me the provision under which you have made the compulsory retirement.
The disciplinary proceeding was initiated.
Huh?
Disciplinary proceeding was
It's okay. But I'm
Under-
asking,
rule 11 of the
11.
minor, rule 11 of the CRPF rules.
where do I find it?
Lordship, it is in the CRPF Act.
Hey.
It speaks about the minor penalties. Sorry, section.
No, section 11 about minor punishment.
Yes, Lordship. Then they proceeded under rule. Rule 27. Rule 27 of the CRPF rules, it's prescribed the procedure to how the penalties to be imposed. So if both the rules are read together, it comes that minor penalty by using the procedure at rule 27 of the CRPF rules. So there is no provision for awarding this compulsory retirement under rule section 11 of the CRPF, section 11(1) of the CRPF Act 1949. So entire exercise is
No,
Yeah.
no. Recently, a judgment has come. 3 judges bench. I think Justice D.Y. Chandrasud was there. Was held that the power is there on the CRPF to go for compulsory retirement. That power is there. That is the.
Lordship,
Can
that
it
is
be
there,
made?
but if the proceeding is initiated under the rule, section 11(1) of the CRPF Act, there is no provision for granting, there is a
No.
it can be granted in other rules.
No. Whatever provisions it was initiated, the court category held that you cannot impose this type of penalty which you are doing it. That is why the division bench held it in that manner. But thereupon, does it stop the authority to go for compulsory retirement?
No,
Doesn't-
then it will have to be compulsory retirement simplicity.
Yes, it is a simplicity. Therefore, I'm saying
Yes.
when there is a compulsory retirement, the power is there to compulsory retire. But it cannot be made retrospective.
Retrospective and by way of a punitive measure, because this is outcome of the what has been given now is awarded as a punishment. Because the removal of service was a punishment. That was, and this was the disciplinary proceeding. Out of the disciplinary proceeding, it is not a compulsory retirement simplicity in the present case. I have stated in para 11 of my affidavit that I have filed recently. It is at page 211. And the impure order speaks itself that I hereby impose the penalty of compulsory retirement from service upon such and such Alauddin Ahmed of this unit with effect from 6/3/2007. One aspect is that it cannot be given retrospective effect.
Now, what do you say about 2027?
Lordship, 27 prescribe the procedure on.
No, okay, 27A4.
The procedure to be followed in imposing different kind of penalty and the authority who are empowered to do that.
No, 27(4) says compulsory retirement
Yes, Lordship, that is the procedure to be followed.
to be
what-
inflicted after formal departmental inquiry.
Yes, Lordship, how these penalties are to be inflicted, that is given. But they have proceeded against me under section 27. If both are read together, because that empowers them. The penalties are prescribed in different rules. Minor and major penalties are defined and they are given in different rules. And in CCS rule, the penalties are defined in Rule 11 and the procedure is defined in Rule 40. 40. 40.
Rule?
Lordship, Rule CCS rule, penalties are defined in Rule 11 and procedure is prescribed in Rule 14.
Of?
The CCS rules. And here in CRPF Act, Rule 29 Rule 11 says about the minor penalties. Rule
Minor
11
punishment.
speaks about the penalties which is
No, section, we are concerned with section 11 of the
yes,
act,
act.
which says about minor punishments.
Yes, sir.
So minor punishments are reduction in rank, fine, confinement to quarters, so and so, so and so. Any punishment under so and so may be awarded by the gazetted with the name as so and so. Now, major are what? Where is major penalties?
Major penalties are not there in the CRPF Act. So when the act is vague, then they will have to rely upon the CCS rules. That is there probably in section 240 or because the Jammu Kashmir High Court has interpreted in this way.
What
What
does
they
it
have
say?
stated, Lordship, there is a judgment of the Jammu Kashmir High Court.
You were, what was your post?
Constable GD.
Constable.
Yes, sir.
So you can be imposed of compulsory retirement by the commandant.
Yes, sir. That is there. That has they have not violated. The
So they have
disciplinary
done
authority
that.
they have kept. In the para 21 of the High Court judgment, it says we have come across Rule 102 of the CRPF Rules 1955, which provides that any matter for which no provision is made in the said rule, that is the CRPF rule, such a condition of service, the members of the force shall be same to be as are for the time being applicable to the officers of the government of India of the corresponding status. This would mean that CCS rules in respect of the respondent are to be made applicable only if there was no provision in the CRPF rules to take care of such exigencies. But since the issue of the question of is squarely covered by the Rule 16 of the CRPF rules, therefore, appellants were not justified in any way to apply general rule, that is the CCS rules in the
No, kindly come to Rule 27C.
Yes, Lordship. Lordship, Rule 27C, it speaks about the how to be penalty is to be imposed, and CRPF Act is silent about the major penalties. So in that case, they will have to proceed. They will have to proceed under Rule 11 of the CCS rule.
No, when 27C is there, the procedure is given.
The procedure is given, but penalty, where from they will get the authority? Because the CCS rule, Rule 11, they will have to rely upon the Rule 11, but they have not proceeded under Rule 11. They have proceeded under Section
What is Rule 11 again?
Rule 11 of the CCS rules. It speaks about the penalties.
We'll come to CCS rules later. First of all, what do you say about 27C?
The 27C only prescribe the procedure as it is prescribed in CCS rule under Rule 14. So the penalties are defined in Rule 11. Similarly, in CRPF Act, section 11(1) says about the minor penalties and major penalties, the rule is, act is silent. So they will have to rely upon the CCS rule for the major penalties. It is there in the CCS rule.
But Rule 27 also includes dismissal of service.
Yes, Lordship, that is the procedure they have given on it. That is the procedure, like,
But are these not the rules made under 309?
yes, Lordship, that is a rule made under
They have the
309.
statutes.
But the penalties are not prescribed. Penalties,
Penalty is there. in
no,
27.
that is the procedure they have given, that these, for these penalty, this rule, this will be the authority and this is to be done. So in like rule 14 of the CCS rules and rule 11 speaks about the penalties.
Why
What
you
is the
coming
minor?
to Rule 11 again?
Lordship, rule 11, I'm not talking about the CRPF Act rule, I'm talking about CCS rule. Because when the CRPF Act is silent about the minor and major penalties, in that case, they will have to rely upon the, as per this judgment, they will have to rely upon the CCS rules. And CCS rule says, in rule 11, the penalties are defined, what are the minor penalties, what is the major penalties. Rule 14 says, how the procedure to be followed in imposing such penalties. That is given in the rule 27 of the CRPF rules. But the the CRPF rule is silent
Are
about
you
the major penalty.
saying the power which is being given under the punishment which is being meted out in Rule 27 cannot be imposed?
Yes, that can be imposed, but then they will have to proceed under, they will have to take help of the rule 11 of the CCS.
Why?
Because it prescribes the penalties. It speaks about the penalties. Rule
No,
14
but the Rule 27
Rule
also gives
27
that.
says only about the the procedure.
No, kindly see.
No, they have stated about the penalty.
No, 27A categorically says about the punishments.
Yes, Lord.
27C says the procedure for conducting the departmental inquiry.
Yes.
Why should we go to the CCS rules?
Now they have not, they have started the proceeding against me under Rule 29, Section 29, invoking Section 29. If both the rules are read together,
Section
29. Oh, sorry, Section 11(1).
11(1) is okay. I'm not on that. Now the question is, if you want to impose a compulsory retirement, there has to be, which is permissible as per 27A. You have to have a departmental inquiry.
Yes, Lord.
Now, departmental inquiry has been stated out there in 27C.
Yes.
Now, 27C says that substance of acquisition shall be reduced to the form of a written charge, which shall be as precise as possible. The charge shall be read out to the accused and given to him a copy of within 48 hours before the commencement of the inquiry, whether these were done or not.
That was done.
So therefore, if these, whether these charges were there, after that, after commencement, a year will be asked for guilty or not guilty, whether document the
That
accused
entire
has then been
procedure has
examined
been
and
followed.
statement has been recorded. If the accused refuses to cite any witnesses, so and notwithstanding anything where a penalty is imposed on a member of the force on the ground of conduct which has led to conviction in a criminal charge, where the accused is competent to, authority is competent to impose the penalty is satisfied for reasons not necessarily reasonably practical to hold the inquiry again. With four more members of including so.
Lordship,
So the power is given here. This is how it is to be done. The question therefore arises out here is that if you are imposing the punishment of compulsory retirement, could you have done it from a date initially?
that cannot be.
That is the question. Why you are going into all the other aspects of the matter? If they are going into compulsory retirement, very well. Now, the reason why normally compulsory retirement cannot be with a stigma, the reason was very specific that you don't need a departmental inquiry.
Yes.
But when here the punishment categorically says that the departmental inquiry will be gone into for the purpose of imposing the punishment of compulsory retirement also, then where is the question of stigma? Isn't that the basic philosophy of a compulsory retirement? That compulsory retirement goes without a stigma unless such there is no requirement of an inquiry.
Yes.
The basic idea of compulsory retirement is that he is a deadwood. So therefore we do it. But if it is imposed as a punishment, then it has to be imposed, cannot be made retrospectively from another date. That is the issue. Why should we go into all other things?
Because that time I took the earlier, right? That penalty was disproportionate. That plea was, I have taken. That's it.
And that I have understood.
Lord.
Therefore, I've asked you to put it by way of an affidavit.
Yes,
This
Lord,
respect
I have
to
to.
matter. So that now, if we make it till date, from the date of that order,
Yes, Lord.
go without touching on the compulsory retirement and make it on 4th of January 2017.
Yes, Lord.
So from 1994, you were working.
Yes, Lord.
You have a pensionable service.
Yes, Lord.
So that is the way,
Yes, Lord. That, because
making it
now I am-
lengthy, unnecessary CCS rules. Why should we bring in?
yes, Lord, if that can be done, there accordingly pension may be granted, that observation is given.
You'll
Then-
be entitled to the pension and all. Because
Because
it
the rule
cannot
40
be.
says, it,
Show me one judgment to that effect or any law, which I know is the compulsory retirement cannot be made backdated from.
penalty cannot be imposed retrospectively.
That is the only thing which I want. You find out. The judgment, you will give it to me tomorrow.
Yes,
And pass the judgment
Yes,
in the open court itself. That is the point. Exactly, that is the point on the issue. Running around, beating around the bush is not helpful. And if we have to beat around the bush, the matter gets delayed unnecessarily. If you are entitled to a payment of a pension, you will get it.
Yes, Lord. That is,
At the end of the day, that is
That is
what I recorded in my last order also.
yes,
The asking you to go back to that position does not arise. Because here, if we see 27, it makes it very clear that you can inflict compulsory retirement to be inflicted after formal departmental. So it is shown as a punishment.
yes, Lord.
Is the matter having been substantially heard, is the matter tomorrow. You take this. There's one judgment that compulsory retirement cannot be imposed prospectively.
Lord, well. Lord, check. The judgments are in the line that the penalty cannot be given retrospectively.
Find out. Yes, Norman.
No eviction has been done till now, Lordship.
Huh?
We have received a latest instruction. No eviction process has been.
Right? No steps have been taken in spite of there being an order passed by this court. This court had made it very clear. I think this is Guya thought. Very, very clear.
Yes, Lordship.
Why you haven't been taking steps?
The reason they have not stated here, Lordship. Only this is.
Only by 1 meter.
My lord. 1 meter. My lord, because the fire brigade, my lord, fire brigade cars, they cannot enter, my lord, even in register, my lord, offense, my lord. Then fire brigade cars cannot enter in that road. In our petition, my lord, they have can you see page, my lord, page 39, my lord. Page 39. They have page 39, serial number 52, my lord. Page 39, serial number 52, my lord. So it got exactly what number 24.
Now we let's turn to page 36, my lord. Format showing requirement of proposed acquisition of land of narrow roads in GMC area, including provision of drains feasibility for movement of higher tender.
Page
Page 36, my lord. 35 and 36, my lord. They have mentioned some, my lord, important roads, my lord, in the wards, but they have not, my lord, depicted, my lord. Page 35 and 36, my lord.
now, madam, if you kindly come to page 16 of the petition. 16. Paragraph 15. In view of such conflicting stand taken by the parties which involve disputed position, court is of the view that necessary exercise should be carried out by the establishment of the deputy commissioner to find out the nature and character of the Sohit path in the Zotia area of Guwahati, and shall, with the assistance of the GMC officials, find out whether the road is a public or a municipal road or a private road carved out of the patta land of the petitioner, and after giving reasonable opportunity of hearing to the affected person, shall do the needful. Deputy Commissioner and the GMC officials shall also find out whether the person residing behind the residence of the so and so. Thereafter, necessary follow-up action shall be taken. The above exercise shall be carried out so and so. So what has the GMC done? Yes.
Instruction, my lord. Initially, that some roads are narrow, that has come to light, so that instruction I need to.
The actions have you taken? And what the GMC has done, have you conducted any, DC, have you conducted any hearing? Yes, madam. What is wrong? Does the matter come every time? So many orders have been passed out here.
Yes, lordship takes the matter. So pending lordship, I would.
What is every time instruction?
That-
And who is the respondent number 6?
My lord, he has left, my lord, from that land, my lord.
So we strike out his name.
Yes, ma'am.
But who is in occupation then?
Now, no opposition, my lord.
Huh?
No opposition.
What remains? Now, who is it? Is the respondent number 6 encroaching?
Earlier there was encroachment, but he has left, so my lord, we have started copy, but it was not reached. my lord.
And you see paragraph 6 of your
Yeah, yes, my lord,
petition.
yes. I see.
So if you say that the respondent number 6 has already left, your entire cause of action has ceased.
No, my lord, that from the beginning, from that
No,
land,
no,
my lord.
kindly see
The entire
paragraph.
entail.
No, Mr. Rahman, kindly see paragraph 6. Isn't it your case that respondent number 6 is the person who is doing it?
It may be
And if
some,
that
my
be so, if you say that the respondent number 6 has already left,
I
nothing remains. There
may
might
be,
be
but
somebody else.
may I pray, my lord, I also need instruction, may I
Huh?
maybe fix on, my lord, 4th of January, my lord.
Tomorrow,
Tomorrow, my lord.
first of all, you have not taken steps.
Tomorrow,
Just find it out.
my lord, tomorrow.
What's the matter tomorrow? 2 p.m.
Okay.
Mr. Bora, kindly get your instructions on this. What is that? What has happened?
Your lordship, we have submitted the, this honorable court's order, lordship, and accordingly the next date is preponed to tomorrow, lordship.
Fantastic. Let us have it on 3rd of January. List the matter. Mr. A. Ahmed, the learned counsel appearing on behalf of the petitioner submits that pursuant to the order passed by this court on 29/11/2024, the learned trial court has preponed the matter and thereby fixed the matter on tomorrow is what? 17th of December 2024 for evidence of the further PWs. Who's to list this matter on 3rd of January for an update. Let's have it on 6th of January. Right? And the counsel appearing on behalf of the petitioner shall also produce the latest copies of the orders being passed by the learned trial court.
It has passed an order on 13/11/2024 because of contradictory stand for DFO and newspaper. And accordingly, they have filed an evidence.
Mr. Bora, nowadays you have stopped going for e-auction, na? You are for e-auction everything? Mr. Das, what remains further?
Actually, it doesn't, because they have also now, I have seen that they have sought for apology for this court.
So
Yes,
I think we have to be more gracious enough and show the mercy. And instead of doing all these things against them, but I hope they have learned the lesson. Have you?
They will not do in near future also.
I think near future, they will not do that.
One indication, your lordship, that I just remember that your lordship has said in this case, whether certain guidelines can be issued in some of the cases, just
No,
UK lights.
now doesn't it mean we're taking into
Yes.
account that otherwise all forest department matters are done by e-auction.
Yes.
Now BTC have also gone for e-auction. So under such circumstances, nothing
Done
remains.
also, like a persuasive order that has been passed, it is completed. We also participate in ultimately, I think we have got it, the particular. So that's nothing remains, but I hope that this newspaper also learn a lesson, other also learn lessons in view of this particular case. There are few cases in fishery department which is still going on.
But somebody may not have inquired in the manner I have done.
No, we brought notice to the court, as your lordship, we brought notice to the court. We have shown two newspapers in fishery case.
But did you go for the DIPR thing?
That's but this is what lordship indicated. No, that part, the court also found that yes, absolutely, that they have done it. But DIPR, I have not also that relevant time. Only where lordship has indicated, then we have come to know that DIPR. Okay, my lord, thank you.
Mr. Dida Kalani, Senior Counsel, assisted by Mr. H.R. Ahmed. And Mr. S. Bora appears on behalf of the Boroland Territorial Council, and Mr. J. Roy, the learned Senior Counsel, assisted by so-and-so, appears on behalf of the respondent number 11. Pursuant to the orders being passed by this court, it has orders being passed by this court dated 5/9/2024, 26/9/2024, 13/11/2024, and 27/11/2024. It has been informed to this court that a fresh advertisement have been duly issued and issued by e-auction. And thereupon the tenders have been duly finalized. It has also been brought to the attention of this court that these e-auctions were issued pursuant to proper publications being made in 3 newspapers. this court had also seen the affidavit which have been filed by the respondent number 11 through the owner of the newspaper, Sanseri and Bodosa, wherein they have expressed deep apology, unconditional apology for certain infractions being committed by them. This court taking a magnanimous view of the matter is of the opinion that nothing further remains to be nothing further remains to be adjudicated in the instant writ petition, for which the writ petition stands closed. This court has really accepted the unconditional apology by the respondent number 11 as tendered by the affidavit filed today, to Silum. Number. Yeah, what is this?
Madam Lordship, similar issues pending before the Supreme Court Lordship. That is SLP 2084.
What is the matter about? The counsel appearing on behalf of the respondent seeks for an accommodation taking into account that the matter is pending before the Supreme Court. Similar issues is pending before the Supreme Court. So taking into account, list this matter for 6 weeks.
May I please, Your Lordship?
Yes.
Your Lordship, the writ petition has been preferred due to not releasing, Your Lordship, 30% of the subsidy on plant and machinery of my unit, Your Lordship.
Has the affidavit been filed?
Yes, if it been filed, Your Lordship, I have filed my rejoinder also, Your Lordship.
It has been submitted that the affidavits have been, pleadings have been duly exchanged, taking into account above, rule is issued. The writ petition is admitted for hearing. List the matter for hearing in the month of March 2025.
Nice.
Much obliged, Lordship.
Yes, PWD. What is the matter about?
Your Lordship, this relates to the non-payment of the contractual bill. This is the second round of litigation. In the first round of litigation, the matter was remanded back to the director of sports, wherein they have calculated and they have deducted further amount, which they could not have. My entire claim, which remained, was 16 lakh something.
Now, why are you not filing a civil suit?
Your Lordship, there is no dispute as regards the payment, Your Lordship,
Then why are you before this court then?
because there is no disputes as regards the claim, Your Lordship. It's very clear that the amount has to be paid. Now,
Then?
I'll just place the facts in this way. There was some installation of high mast and the lights of all the unused things, and all those things and the replaced things has been placed at the disposal of the Sports Authority of Assam. Now they said that they don't find that replaced goods.
Huh?
The Sports Authority have said that they are not finding the replaced goods, all those unused materials which has been installed. Now PWD was the executing authority. They have given a salvage report of all those goods because these are unused goods. In spite of that, they have deducted the amount, Your Lordship. That's my precise case, Your Lordship. So when the executing authority has precisely given a salvage report, now how can the director of sports says that they will not agree to that?
Yes, PWD, what is your stand?
Lordship, I have not received instruction.
What?
I have not received, yes, Lordship, on the last occasion, Lordship.
Who is appearing for respondent number PWD?
678, Commissioner Building and.
You have not filed your affidavit?
Yes.
Why? The
Lordship,
new matter. Very new for PWD, na? 2022,
That's a short time, that's it.
very new matter. Mr. B. Chaudhary, the learned counsel appearing on behalf of the PWD submits that within 10 days, the affidavit would be filed on behalf of the respondent number 6 to 11. To list this matter again on 27th of January. In the meantime, the respondents, PWD, are directed to bring on record their stand on or before 21/2024, 5. The petitioner thereupon would be at liberty to file.
Lordship is fixing it on 27th. 27th, Your Lordship. Deeply obliged, Your Lordship.
What is this?
My lord, the petitioner again before this honorable court for rejection of their offer for my lord, retail outlet. Their LAC. has
So you're
been-
running it
No, my lord, they have not, but J motor is in operation.
where? Says any such settlement with to the demand to the so and so shall be subject to the outcome.
Subject to outcome. Because
There's
of
no
that, my
interim
lord-
order.
Because of that, my lord, process has been stalled. My lord.
And who is appearing for the private respondent? Anybody? No, there's no private respondent.
No, but
Now what have you done?
my lord, since my lord, they did not, my lord, fulfill the criteria as per the, my lord, advertisement as per the dealership, my lord, guidelines. My lord, that is why that has been rejected. In the earlier occasion also, my lord, the petitioner was absent before this honorable court
Is it?
on 23/5/2020.
Yeah, it
We
is
have
not
filed
so.
our affidavit.
Earlier it is seen. Okay, none appears on behalf of the petitioner on call. Mr. D.K. Sharma appears on behalf of the respondent, IOCL. IOCL. It is seen that the petitioner have not filed the affidavit in reply in spite of the due opportunity which was granted by this court on 17/7/2023. Mr. D.K. Sharma submits that in view of the pendency of the instant petition, the respondent authorities have not further proceeded with the said tender process. He therefore submits that the matter be disposed of at an early date. So taking into account the above, placed the matter on 7th of February 2025. If on the next day the petitioner is not represented, this court would have no other option but to dismiss the petition for non-prosecution.
Yes, please, your lordship. Petitioner has submitted all the documents which were sought for launch.
When?
13/11.
13.
13/11.
What is your stand, Mr. Parasar?
Malat, she might have submitted to the state government. Malat, last occasion the direction was there. We have not received the latest instruction, Malat.
We have
Mr. K.K. Parasar, appearing on behalf of the union, as well as Ms. S. Volvo, appearing on behalf of the state, submits that they have not got any updated information as regards the petitioner's entitlement have been processed or not. Mr. Ms. So-and-so, appearing on behalf of the petitioner, submits that on 13/11/2024, all the due formalities have been duly complied or complied. Just taking into account the above, list this matter again on 29th of January 2025 for an update by both the state as well as the central government.
21st January.
29/1/2025.
Lordship, copy of the petition.
Malat, will
Okay, none appears on behalf of the petitioner on call. This matter after 6 months.
Lordship, here I'm
paying for some accommodation due to some problem.
Last time you had a very
Yes,
sore
Lord.
throat, now your
Yes, Lord.
throat happens to be perfectly fine.
Yes, Lordship.
Then-
Yeah, for some personal medical reason, Lordship, I couldn't prepare it. That's why immediately after on reopening, Lordship. Only due to non-preparation, Lordship, I'm honestly.
I have a very small prayer. Let the security deposit upon furnishing of some loan, my lord, can it be directed to?
Let's dismiss their petitions. Right, Larry? Yes. समझो बाकी petition. आगे what is the why should we exercise writ?
On revisional order, we have challenged.
Tell me,
Uh,
what is your ground?
Ground is that, Lordship, there is a circular of the department wherein it states that in case of the IMFL product, a Lordship, while taking it for that audit, it should be examined thoroughly so that the documents which prove that the order was placed and the goods have reached their destination are properly verified. In this case, Lordship, the assessing officer found that the most of the transaction that the respondent did with the particular dealer of Arunachal Pradesh, Lordship, on verification, it was found that their excise license was cancelled way back in 2000, whereas he dealt with that particular entity till 2009. And so, and it was, since it was cancelled, all those interstate sales transactions were deemed to be intrastate, Lordship. And there are other accounts also undergone sales. It was found that the transaction details that he gave, and that was also because the records that he was supposed to maintain, he informed the authority that it was destroyed by fire. And so he, in a piecemeal manner, he gave some details, and on that basis also there was suppressed sales. But at the revisional stage, Lordship, he produced some document on the basis of those documents without cross verification. The revisional authority accepted that and set aside the assessment order, and it was remanded back to recalculate. And Lordship, on that ground, that there was no basis of the revisional authority to discard those assessment made by the assessing officer, Lordship. And secondly, the circular was not followed. That was in circulation at that point of time. That was not followed, and there was no cross verification. And whatever document in the revisional order, it was stated that it is accepted to Lordship. Those documents were later on not found in the records.
Where's the circular?
Lordship, page 121. 121, Lordship. If Lordship is taking up 4463.
How this circular helps you?
Lordship, this helps in the sense that, Lordship, at the time
It
of
is
the,
for the purpose of assessment.
yes,
Now, whether during the assessment he has done it or not, that is another aspect. If he has not done it, then you go for sumo motu revision. That is the issue. Now, here we are concerned how, why is it that the sumo revisional authority has to follow this?
because at the time of the assessment, Lordship, the assessing officer, following this circular, he asked for
He may have done it.
he has done it.
So he has done
but
it, but does it
although-
mean that the revisional authority has to follow this?
But all those process that he has undertaken that by the assessing officer, that has been discarded.
Let us see there. Let us see that.
Lordship, page 99.
With 102. How many years, financial years we are concerned?
From 2005 to 2009, Lordship, both under VAT and CST.
Notice,
Lordship, here,
notice. How can we enter into those factual aspects? Here, there are two aspects. First is interstate.
interstate,
Interstate, they have given all the 95% of the sales were made to Arunachal. The Arunachal authorities and the Nagaland authorities have duly confirmed. Yes, these were interstate sales, confirming the CC. The second is as regards the underbond. Underbond, initially, they could not submit the various documents out there. At the time of, they also submitted that was incomplete. But later on, they duly proved it along with, and by corresponding, correlating with the excise documents. Then, what case? Unless you say that these were all fraudulent documents which could not have existed. Have you brought in on the record anything to the effect? Then what case you have? You have a case. How can this court exercise 226 on these? Unless you have some material. Yes, these are fraudulent, which could not have, that you have made thereafter inquiries with the, that the state have thereafter made inquiries with those officials out there and found out this, that these are, that person who have given those certificates are also false. Did you find out anything?
that lordship, the certificates and everything were produced at the revisional stage. And the revisional authority ought to have initiated those movements because the,
You were, your superintendent was duly present. The person who, the assessing officer was present out
Yes.
there.
Yes.
So he may have said it's something that these are fraudulent, but have you at any point of time come up that these certificates you made for the inquiry, that these certificates were not issued? Because at the time of the initiation of the revisional proceedings, the earlier, not this revisional authority, but the earlier revisional authority had made an inquiry with all the four states.
yes, lordship, yes.
Jharkhand and West Bengal did not come up with the detail, but other two states wherein around 95% of the year was there, they have, the authorities came up and said that yes, these are where C forms which have been duly issued, there was interstate sale and all these things. Then, they're all questions of facts. What remains now? Tell me, how do I exercise 226 here?
Allow me some time, lordship. I will.
For what?
I will try to further go through and go through the records once again, lordship.
You have made your case on the basis of the circular which could not have been made. The circular has no basis out here. Fact that there was an interstate sale which has been proved. The fact that there was an underbond sales which were there, which were also improved by all documents. They said that they have lost those in fire. However, they were able to reconstruct them and correlate with the excise departments.
But lordship has seen that the excise documents that were produced, it was simply stated that it was cross-verified with the list of sales given by the respondent. It was not cross-verified with the authority.
Now, these documents, where are the records?
Records are lordship in Tinsukia.
Records are with you.
Yes.
Produce the records. We'll look into it. The matter having been heard at length, this court is of the opinion that there is a requirement of perusal of the records, which the orders were being passed by the impugn orders have been passed by the revisional authority. This matter again on 21st of January 2025, showing it as partnered. Mr. So-and-so, B. Chaudhary, appearing on behalf of the state of Assam, is directed to produce the records. You otherwise there's nothing. Your petition is too vague. You just file this for the sake of it.
Lordship, it was initially filed before the Board of Revenue.
Board of Revenue also doesn't make any sense. Unless you
Yes,
come up with
Lordship.
your basic case has to be that you have made inquiries with those officials.
Subsequent
that it
inquiry
was not correct.
has to be there.
But otherwise, not on the basis of the circular, you don't have a case against this. Yes, madam. Anything?
General authority, they have convened a meeting on 22nd of November. And accordingly, the forest department was asked to submit the needful the papers, which was documents which was needful for the matter. And they have already submitted, but the committee has not convened a meeting here as yet.
Yes. Why is it taking such a long time?
Lordship, in the month of November also, there was a meeting held between all of Lordship parties. And as per that resolution, Lordship, Kala is Lordship, I've just now got that etc. Lordship, the committee discussed the issue of the tribal families of the reserve, Rampur Reserve Forest, not allowing officials on and as well as so and so and so. For 63 families dwelling in the part of the Silrampur Reserve Forest in respect of which notification for acquisition has already been published for preparation of 3G estimate will be completed by 30/11/2024 by the Kala. Then Lordship, within December, Lordship, NHI is to deposit the amount, Lordship. But thereafter, Lordship, instruction is not coming, Lordship.
You have it in the month of January.
Lordship.
Council appearing on behalf of the Karbi Anglong Mr.
Ask me to that one,
appearing on behalf of the HIDCL has submitted that some further time is required in view of the meeting, which view of the outcome of the meeting, which was held on
25th 11/2020.
25/11/2024. Taking into account.
Lordship,
above.
14/11,
Huh?
sorry, 14/11.
14/11/2020. No, not 14. It has to be subsequent.
Yes, Lordship, 14/11 at 2:30 PM, Lordship.
14/11/2024. Matter again on 8th of January 2025.
23.
Yes, government, file affidavit.
Yes.
You want to file reply?
No, this they admitted our
Huh?
grievance.
What is the case about?
But the petitioner are the beneficiaries of Pradhan Mantri Awas Yojana scheme, my lord. They are job card using by their job card in the name of other person. They have get some account and the benefit of the scheme given to them.
No, that affidavit is not on record.
It is
It
filed
is
on
submitted- Mr. Nan has
25/9.
appeared on behalf of the PNRD on call. The council appearing on behalf of the petitioner further submits that an affidavit has been filed by the PNRD. However, the same is not on record. List this matter on 8th of January. The registry shall bring on record the said affidavit filed by the PNRD.
24. Item 24.
Where is that Mr. D. Nath appearing on behalf of the PNRD? Yes, Mr. Nath, have you disbursed the amount?
But my instruction is that from the Kala, they have not, from the Kala, now, the Kala has to send the calculated amount to the PWD for payment. Payment, the amount is already with the PWD. The Kala has to send the requisition, whatever amount they calculated after calculation.
Allah has to send the requisition for what?
The Kala has to calculate the amount and give it to the.
Has it not been determined?
It has to follow the.
No, you said that earlier, the Mr. Dane Learning Council appearing on behalf of the PNRD, PWD submitted the file has already been received on 25/10.
But amount is with them. Now the Kala has to calculate and give it to the PWD for release.
The Kala has accordingly calculated and given. This appears from the, therefore that this has happened. This is the amount which has been already given by the revalidation also done by the government of India.
Yes, yes, Malad. Revalidation of financial sanction has been given in October 2024.
Then,
Now the fund is with the PWD. Malad,
accordingly, the circle officers have reassessed the compensation and submitted 3A, 3D and 3G. 3G is the compensation with an additional amount of rupees so and so, and only, and the same has been sent to the executive engineer PWD for taking necessary for providing fund.
But that has been taken up with the Malad MOT, and MOT has already revalidated the sanction. And now for release of the amount, the Kala has to ultimately give the final thing, and accordingly the amount will be.
But why are you not doing it?
But the deputy commissioners, the Kala's instruction is not with me, Lord.
Yes. Why you not doing it, deputy commissioner? The additional deputy commissioner, why hasn't the Kala has done it? No, we are not concerned with what is your internal arrangements. The fact that the petitioner should get the amount, that is the question. We are not inclined to make the payment, and dilly-dally in your offices out there, who is going to pay the interest?
Well,
Did it go from the office of the additional district commissioner? Who is the Kala? Are you going to pay the interest? You delaying out there amounts to the other person is entitled to the interest. If you are delaying, once the revalidation has been done, why are you not taking any action? Have it on 28th. Get your instruction, whatever is required to be done. Heard Mr. D. Nath, the learned counsel, appearing on behalf of the PWD, as well as Mr. S. Bulwa appearing on behalf of the additional district commissioner. Which one?
Dorong.
Full stop. From a hearing of both the councils, it appears that there seems to be an inter-departmental tussle as to who is going to send which document first. Full stop. We are concerned out here as regards the entitlement of the petitioner and the rights under Article 300A of the Constitution being infringed. Full stop. These interdepartmental tussles should not in any manner relate to, should not in any manner delay the disbursal of the amounts to the persons entitled. Full stop. List this matter again on 20/12/2024, on which date both the authorities, that is the additional district commissioner Tarong, as well as the PWD officials, shall apprise this court as to whether the amount have been disbursed.
Relating to election of cooperative.
Matter relating to?
Election of cooperative society. Lordship, in this case, Lordship, I have obtained instruction my client Lordship as to Lordship whether the case is survived or not, Lordship. Lordship, after vacation, Lordship. Lordship, my senior is on legs in another court. Matter may be taken up at 2 p.m. Matter may be taken up at 2 p.m.
Why?
Senior is in legs.
Election over?
No,
Elections are not over?
Lordship, after vacation, Mr. Lordship.
Elections are long over. What remains? If you have any problem, why haven't you moved the for cancellation or the setting aside that? You should have challenged it as per that provision of that rules. If you have any problem, you should have gone and challenged it as per the Assam Cooperative Society's election rules. You have not challenged it. What remains? Elections were held when? Elections were held on 25/4. Then what remains out here? None appears for the respondents, also private respondents. The counsel for the petitioner seeks for an accommodation. First up, it is also noticed that none of the neither the official respondents nor the private respondent has filed their affidavit. List the matter after 6 weeks.
26. Yeah, please. In this case, my lord, respondent has not filed any affidavit in that case.
Huh?
Not filed anything.
What is the matter about?
My lord, better parties to my lord, eviction from landlord.
Huh?
Eviction.
Eviction? By whom?
By the GMC, my lord.
GMC has evicted you?
Earlier was my government evicted my lord. Thereafter, petitioner moved approach this honorable court lordship. Lordship, there is an order in case number 24. Case number 24, there is an order to consider my application and till the consideration of my application, my lord, there is no eviction. But in the year, I will begin 29 April 2023, my lord, without any notice, my lord, being evicted.
You've been evicted? By whom?
Now, my lord, by the GMC, my lord.
How?
Some official of the Deputy Commissioner and official from the Guwahati Municipal Corporation, along with police personnel on 29/4/2023, my lord.
29?
29/4/2023.
You've been evicted?
Partly evicted.
What is this partly evicted?
Some house demolished, some father. I told this honorable court, my lord. Honorable court lordship granted protection. Since because there is already an order lordship from this honorable court lordship, at page number 24.
Now, how is the GMC evicting you? Under what provision? Where is your statement that the GMC has evicted you?
My lord, a page number 9, a paragraph 11 lordship. Some official from the office of the Deputy Commissioner, as well as the official commissioner of the Guwahati Municipal Corporation. But they claim themselves that and but there is no notice lodged.
Yes, government?
Long pending matter, but fortunately we are yet to have the instruction.
So we said is that as you have not done so, return whatever it is. Without due process, how are you doing all these things? Isn't it high-handedness on the part of you and the GMC officials to do all these things? And there's no reply to paragraph number 11. So under the doctrine of non-traverse, we should follow.
Let it be on a reporting, we will file an affidavit by then. Because ultimately it has come up for the second time.
The case of the petitioner hearing is that the respondent authorities, more particularly the state of Assam, more particularly the Deputy Commissioner Kamrup Metro, as well as the officials of the JMC, have partly evicted the petitioner on 29/4/2023 at 12 p.m. without any notice information and demolished some part of the house of the petitioner over the said land in question. This court had issued notice on 10/5/2023 and had also directed the parties to maintain status quo as on date in respect to the piece of land under reference. The respondents, however, have not responded to the said notice issued by this court, and more particularly to the allegations contained in paragraph number 11 of the writ petition. From a perusal of the non-traverse to the said allegations shows that the allegation, it is observed that in the circumstance, the statements made in paragraph number 11 of the writ petition are true. It is a clear infraction to the rights of the petitioner, taking into account the above. This court for the ends of justice grants an additional opportunity to both the state, the Deputy Commissioner Kamrup, as well as the Guwahati Municipal Corporation to respond to the said allegations. It is observed that failure to traverse this form shall construe that the statements made in paragraph number 11 of the writ petition to be true, and accordingly would not only have to pass orders for restoration of the possession of the petitioner, but also impose certain compensatory costs upon the officials responsible as per the well-settled principles of law. The petitioner is given the liberty to file an additional affidavit as regards the cost and the loss suffered by the petitioner on account of the actions as alleged in paragraph number 11 of the writ petition. List this matter again on 10th of January 2025. Interim orders passed earlier shall continue.
27.
If it is, you don't file it next time when it comes before this court, will not only impose restoration, but also impose upon the officials concerned the amount of compensation as suffered by them, which they are going to. What I report.
I will ensure that affidavit is filed.
File or don't file, that is your lookout, but this is the consequences which will befall upon both of you. Yes, what is this? Hello, none appears on
27.
behalf of the petitioner on call. So it is also noticed that the respondents have also not filed their affidavit. List the matter of the 6 weeks.
Item 28.
If is your lordship. Lordship, it was regarding payment of compensation. Lordship, now they have in their opposition, lordship, they have filed that as per the guidelines, lordship, that were earlier given, they'll be paying as per the assessment of the district authority. So regarding that, we have no objection regarding that.
Why you are not going before the district judge?
Lordship, if the assessment we are not satisfied, then only we can appeal under section 16 of the Telegraph Act. So the assessment has not been properly done. by
Not
the-
done or done?
Problem was, this power grid line was
installed 30 years back.
Lordship, for transmission of line, it was erected in the year 1987-89. Lordship. For that, they are claiming compensation, not after gap of 35 years, Lordship.
But for that, Lordship,
I've stated in my
New
affidavit
line-
in opposition, my lord. No new line has been erected, my lord.
power line has been
Only
increased.
some lordship, the renovation was going on, lordship. I've stated
Upgradation
in
of
my
line.
affidavit, my lord.
Upgradation of line has been going on, Lordship.
No, they have categorically stated in the affidavit that to the effect that in the year 1987,
Yes.
this was being done. There's no reply to that. So why should we entertain your petition after 35 years?
Lordship, this,
Unless you
So this-
rebut to those statements.
yes, Lordship. Lordship,
The
because
council
I did
appearing
like-
on behalf of the petitioner submits that he requires 4 weeks' time for filing the reply. This matter, after 6 weeks, in the meantime, the petitioner would be at liberty to file the reply.
29.
None appears on behalf of the petitioner on call. Also notice that this court had issued notice on 23/6/2023. Full stop. The respondents have also not responded. Just taking into account the above, this court fixes this matter again after 6 weeks.
Maybe the Lordship. Lordship, in this matter, there are 3 petitioners, my lord. My lord, 3 petitioners and 3 FIR lodged in Silchar police station, my lord. My lord, alleging their land grabbing, my lord, and demolition of their ancestral double-story building, my lord, and illegally cutting off their fruit-bearing coconut. tree,
By
my lord.
whom? By whom?
My lord,
Who has
FIR
done that?
on 15/1/2023, name Selimuddin Chaudhary, my lord. Illegally cutting off their fruit-bearing coconut tree, but after the FIR lodged, neither any action, my lord, by the police.
Why should we pass directions? In this case, where you have not made him a party? One. If you have any problem with the police, why haven't you gone under 156(3)? Two. If there is a civil dispute, this is purely a civil dispute. Why you have not gone to the civil court? 3. Give me the 3 good reasons why we shouldn't dismiss it. That's the answer to the 3 questions.
My lord, no other instruction from the other
Forget
side, my
about
lord.
them. We are not concerned. Tell me, you were lucky enough to get a notice and be happy for a year or so. Now go to the civil court. Better off. Instead of spoiling your time, better, why are you not going to the civil court? If there is any infraction to this, nothing is going to happen out here. If the police is not registering a case, police is not doing anything to that effect, why are you not going before the magistrate? Magistrates are there. Don't rush out here and file your petition out here. These are absolutely purely civil disputes. Go there.
Then matter may be fixed after.
No, matter finish now. Dismiss.
My senior is now out of station, my lord.
Your senior is out of station, I can't help it.
Already section says that FIR has been closed, investigation has been completed, and nothing remains. This is a personal paternal property. They are the owners, and there is a.
The private,
So they have.
Halim Ahmed Chaudhry.
Yes, they continuously they are disputing over the property.
Who they?
Yes.
Better you there go there. If I hold that, you will be in trouble. If I hold that instruction, it means for all times to come it is ends. Case registered as?
FIR.
FIR has been registered as?
PS case number 327 of 2000.
This must be name of something, Silchar. Huh?
It's a PS case.
My lord, only for day, my lord.
Which one? Dismiss. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. S. Bulwa appears on behalf of the respondent state. First, the instant petition has been filed challenging the inaction on the part of the officer in charge of the Silchar police station in respect to the FIRs which were filed on 16/1/2023, as well as the subsequent subsequent information being given from time to time. Mr. S. Burwa, the learned counsel appearing on behalf of the respondents, submits that pursuant to the FIR which has been filed on 16/1/2023, a Silchar PS case number so and so number
327 of 2023.
under sections
448, 427, 379, 34 IPC.
IPC was duly registered. After due investigation, it was found that it was a civil dispute between the petitioners as well as the respondents, as well with the petitioners and one Halim Ahmed Chaudhry. And accordingly, the final report has been submitted. Final report, no?
Yes.
Final report has been submitted. Taking into account the above, nothing further remains in the petition. Accordingly, the petition stands closed.
33.
Lord, this is regarding non-payment of victim compensation, the petitioner.
I just want to point out that no copies of the writ petition have been served upon us till date.
Yes, what is that? You claim to be entitled for what?
Lord, the victim compensation now, earlier order lordship will find at page 44.
44. What is the?
Page 44 is the Millard earlier order passed by the Honorable Court. And operative part Millard page 47.
Then
Millard lordship kindly see the impugned order at page 50. And my lord, the operative part Millard page 52. On the ground of Millard limitation, Millard, our prayer has been rejected.
Where is the limitation clause out there in the agreement in the,
That your lordship will find at page 20,
which one clause?
clause 7. Page 24, my lord. Now the Muller, under the Muller Act, Muller, there is no such Muller limitation period. my lord.
This is on account of the death of somebody?
My lord.
Hmm?
Muller petitioner is the Muller mother of the Muller Alaya Begum and Ramjan Ali, who was killed by the mistake.
What is this Fatima Begum? The judgment of Fatima Khatun?
This is another Muller reference case, my lord, in identical case. This honorable court was pleased to pass an order.
Then you move this court.
Yes, then we move this court, Muller page 44. The order was passed by this honorable court. Then Muller page 50, Muller rejection order by the District Legal Service Authority.
Yes, madam.
Copy of the report is served upon me till date, although notice was issued a long time.
What is wrong with you? Why haven't you served?
I'll furnish, my lord. Let us be Muller posted on Friday.
Does it take it after such a long time? You have not served it?
Somehow,
Are you doing something for the benefit
somehow,
of
Muller,
life?
just
Huh?
missed out, Muller. Just missed out, Muller, somehow.
Then why haven't you served?
I'll furnish copy today itself.
Yeah, see, there's already an order for 15/9, 22/10. There was also another order.
Today itself, Muller,
Okay, we impose a cost of 15,000 upon you.
today, Muller, I will furnish.
15,000 upon you, Mr. M.U. Mandal, for spoiling this call. This cannot happen. Ms. So-and-so, R.H. Chaudhary, the counsel appearing on behalf of the Assam State Legal Service Authority, submits that in spite of the notice having been issued on 15/9/2023, the petitioner have not served a copy of the writ petition upon her. So it is also taken note of that there is also an office note on 22/10/2024, wherein also it is indicated that the petitioner had not served copies upon the SC, ASLSA. The counsel for the petitioner submits that he would do so within 3 days from today. The above clearly shows that the counsel appearing on behalf of the petitioner have not given due importance to the issuance of notice by this court and specific statements, specific directions being issued, directing the counsel appearing on behalf of the petitioner to take steps upon the counsels who have represented on behalf of various parties. The action on the part of the counsel appearing on behalf of the petitioner therefore shows apparent negligence. For the ends of justice, this court is giving a warning to the counsel appearing on the behalf of the petitioner, Mr. M.U. Mandal, and restrains itself from imposing any cost. However, similar conduct, if it is seen, this court would have been constrained to impose costs on a subsequent occasion. This is the matter of the 4 weeks.
34.
Lordship matter is related to election. Election of the Adipota New Delhi Market Lordship.
You're protected. The respondents have not filed their affidavit.
Affidavit will be required, Lordship.
Instruction is awaited, Lordship. Need some time.
It is seen that this court, by an order dated 18/9/2023, had passed and issued notice and have also directed maintenance of status quo as regard the shops occupied by the petitioners. Custom. The respondents, however, for reasons best known, have brought on their stand by filing their affidavit, even in spite of a passage of more than a year having passed. This matter after matter again on 24th of March 2025. The respondents are given a final opportunity to bring on record their stand by filing the affidavit. Interim orders passed earlier shall continue till the disposal of the petition.
35.
Grievance is that I am descendant of the teak plantation workers, laborers, settled in old Salamanad forest village under wide for range forest, Perimeter forest division, the decade of 1920.
And
Petition only, I shall not be illegally evicted, my lordship.
from where?
That on my house and the land which I am cultivating, my lordship.
Huh?
Okay, next, my mother's ration card and my voter's ID. Ration card is on page annex 4.
Are you an ST? So
Other
you come under the other traditional
I'm
dwellers.
claiming.
Fantastic. So then you must be showing a document whereby it is seen that you are there for the last 75 years.
Application and nothing has been.
Forget about that. For this court to issue notice, where is the document to show that for the last 75 years from 13/1/2005, you were there?
We don't
No
have,
case.
but my lord, paragraph, my lord.
Forget about that.
My lord.
You have to be there as on 13/1/2005.
Yes, my
For
lord.
the last 75 years.
Paragraph 15 maybe.
To me, a document to that effect.
Clause 13 of the scheduled tribes and other traditional forest dwellers.
First of all, you have to be another traditional dwellers.
Yes.
Forest
My
dwellers.
lord, evidence of the
Be an-
elderly people. my lord.
No. You have the book with you?
My lord,
You have the book?
my lord, I have annexed the. Para 15 may be seen, my lord, clause 13, my lord.
Not clause 13. First, you have to come within the definition.
Yes.
Section 2U.
To you.
See, what does section 2U and more particularly the explanation? Huh? So what does it say?
Other traditional forest dwellers means any member or community who has or at least 3 generations prior to the 13 December 2005. Primarily resided in or who depend on the forest or forest land for bona fide livelihood needs.
And explanation?
For explanation, for the purpose of this clause, generation means a period comprising of 25 years.
So it is 75 years.
25.
So show me a document by which it is prior to
My
13/1/2005.
lordship, the same act under clause 13, my lordship, the same act under clause 13 which says that clause 13, the scheduled tribes and other traditional forest dwellers recognition of forest rights rules 2007 lays down the provisions for evidence for determination of forest rights. In doing so, the verification process of the recognition of petitioner claim, the respondent authorities may record the statement of the elders of Old Salamana Forest Village to ascertain as to whether the petitioner's antecedents for further settled in the village.
First of all, you have to file your application. What is this going to do with
No committee has been even formed. No committee has been even formed. I approached my lordship.
So there is a Gram Sabha.
The village elderly, my lordship, there is a clause 13 gave that their testimony is acceptable.
No case, unless you show some document, you have no business, you are 43 years old.
My lord, some document, my father's, my lordship.
And a similarly situated person like me, Petu, got staying in the reserve from
My lordship,
25,
this is my
1
father's application.
1961.
3/4/1961.
So 3/4 1961, you have given this.
Yes, this is
Okay.
my father's, my lord.
But does it make it 75 years as on 13/1? Then also. nothing remains.
Statement of the elderly,
From
my
this
lord.
very document, Mr. Counsel, you are not 75 years. From this very document where you say that you are there.
My lordship, my ration card has been issued to me long ago, my lordship, and the act allows, my lordship, the statement of the elderly, my lordship, its proceeding is verification is done, my lordship. Village.
You are no longer elderly, you were 43 years when you filed your petition. Thing remains.
No committee has been formed, my lordship, for verification, my lordship.
Huh? And appears on behalf of the respondents, Forest Department on call. A matter is being taken up. Full stop. It appears that the Forest Department have lost interest in the instant proceedings. This matter after 4 weeks.
I love like
36. May it be the. Whether it's relating to education.
Accident?
Growing water. Growing water.
What?
Brahmaputra sub-river also.
Did you die?
Lordship, we are waiting instruction from the SP, Lordship. The district court. And we are waiting instruction from the SP, Lordship.
When you will go out there? Brahmaputra. Gone in fish. Read it, page 22. Type of English. Before that, read another one. Let us have some source of entertainment before we go to the next matter. Police report, read it. What does it say? Page 2013. An unlucky number also. Page 13. Yes, read it. Let everybody also hear what type of English we are to encounter. Read it. On 8/8/2019, one personally, son of Moab Ali, is reported at this PS to the effect that on 7/8 so-and-so at about 8:10 a.m. his nephew, namely Muhammad Islam, 7 years, son of so-and-so, went to beach with his mother in Brahmaputra sub-river Parvat and accidentally drowning in current water. As a result, the said baby was dead. I am available PS staff and SDF visited PU and recovered the dead body near bank of Brahmaputra. After that, the said dead body inquisited by ex-magistrate Bilasipara and sent to Dhubri for postmortem examination for actual cause of death. After that, postmortem report collected from Dhubri and Dr. So-and-so, in his opinion, cause is due to apraxia as a result of anti-mortem drowning. Then, why did you go there? Taking a 7-year-old. Who are you? Who are you?
Father.
You are the
Father.
father. And he went along with whom?
Mother.
What happened to the mother?
He along with his mother.
Both. Son, why do you take the 7-year-old son to this Brahmaputra river? Where is this? Sub river Pordhat. Hmm? And what is wrong with the government? Why is it taking such a long time?
We have to receive the instruction from the SP. We have to call for the record from the district commissioner to SP, which is waiting.
Let the commissioner secretary do it. Make an investigation, find it out and do it. 5 months. Within 4-5 months, do it. Matter ends out there. Isn't it? As per that, whether the child is drowned or not, if it is drowned, it's a public place. Matter over, you give it. Government has too much of money. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. S. Roy appears on behalf of the respondents. Numbers
I appear for 3, 4, 5, and 6.
4, 5, and 6. Mr. R. Bapugari appears on behalf of the respondent number 1 and 2. Ms. N. Wadloy appears on behalf of the respondent number 1. Ekidal Miladi Bude, 1, 2, 3. The petitioner herein is the father of child, namely Ominul Islam. Unfortunately, while his son, who was 7 years old, when he went to take a bath in the river Brahmaputra along with his mother on 7/8/2019, his son, it was drowned, got drowned, and later on his body was recovered by the SDRF. In that regard, a Bilasipara PS /UD case number 15/2019 dated 8/8/2019 was also registered, and the police has also given a report on 24/9/2019 by the and the police has also given a report on 24/9/2019, evidencing that the son of the petitioner had expired upon being drowned in the river Brahmaputra. The petitioner thereupon has applied for compensation on 7/11/2019 in terms with the notification dated 15/11/2014, whereby. Were you asking 4 lakhs?
Wrongly, Lordship.
Wrongly. Whereby the state of Assam had formulated a policy to grant compensation on account of various incidents, including when a person is killed due to accident in public places or in public areas, bracket other than killed by extremists, public terrorists, public miscreants, and due to firing of security forces, bracket close, of an amount of rupees 2 lakhs. The petitioner's representation given sent to the Revenue Department on 7/11/2019 was remained unanswered for which the petitioner has approached this court by filing the instant writ petition. This court have duly taken note of that the coordinate benches of this court have also passed orders, thereby directing thereby directing certain verifications to be carried out and thereupon to make payment. Taking into account the above, this court therefore disposes of the instant writ petition, thereby directing the petitioner herein to submit a certified copy of the instant writ petition to the Commissioner and Secretary to the Government of Assam, Revenue and Disaster Management Department. Full stop. Upon receipt of the said certified copy, the Commissioner and Secretary to the Government of Assam, who is the respondent number 1 herein, is directed to make necessary verifications through the Office of the Deputy Commissioner. Deputy Commissioner where? Dhubri, as well as the Superintendent of Police, Dhubri. And thereupon, if it is found that the petitioner is entitled to, in terms with the notification dated 15/11/2014, shall make necessary disbursement of the amounts to which the petitioner is entitled to as per the said notification. The said exercise be completed within 4 months from the date a certified copy is served upon the respondent number 1. Principal Secretary.
Item 38.
What is this?
Petition has been filed, my lord, for renaming of the island.
Renaming? What does the court have to do?
My lord, they have filed an application before the GMD, my lord.
Absolutely, this court has no business out here. Why will this court issue a writ? Renaming is absolutely within the people. Why should this court interfere? What right you have? What is your right to get it renamed? Tell me.
My lord, here, my lord, petitioner society, my lord, committee had submitted.
Show me your right.
But there is provision for in the GMC Act, my lord, for renaming.
Whatever may be, show me your right. You have come before this court for a right. What is your right which has been infringed? And don't think that this court is going to pass an order and become a post box. What is your right? Better go there, ask Mr. Bora to help you out, or Mr. R. Borputari to help you out. Nothing
They have already approached the.
Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to approach the GMC as well as the. Why GMC? Why you are making? These are GMC roads.
My lord.
Huh? And does the GMC has the power to name the roads?
Name and rename, there is the power. It's also been issued by law. In this lawsuit has to page number 13. The public notice also been issued.
No, it is regarding another road, my lord. But in the
Similarly,
particular case, my lord, they have not issued the public notice, my lord.
What is done by the GMC?
This is some other road.
Yes,
It's some other road.
because in other case of other roads, my lord, they have published the public notice, my lord.
Then?
But in this instant case, my lord,
But what is your right? What right you have? You have no right. Go there. Ask the GMC. Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would be well advised to approach the commissioner GMC. And as such, would not like to further proceed with the instant writ petition. According to the petition that the closure of the writ petition shall not affect the rights of the petitioner to approach the commissioner GMC.
I'm okay.
39.
Yes, what is this?
Order.
Huh?
They are challenging the delimitation order.
And
By last order, we are directed to file an affidavit in opposition order.
last date was in 2023.
Yes, sir, Lordship.
Why haven't you filed your affidavit in opposition?
Have been signed, but today morning I was being informed by the election of India that the legal officer, Mr. Vijay, he was hospitalized and he was only released from hospital today, so he could not go to the approve the affidavit, Your Lordship. So I.
Does it take more than 1 year, 2
No,
months
no,
for doing
that
that?
is my. But we are able to file this affidavit today itself, Your Lordship.
They filed it.
Oh, I couldn't, Your Lordship. It has already been signed by the joint CEO of Assam, but it's still we couldn't find it because in last moment I received the instruction from Mr. Vijay that he asked me to hold it for a couple of days. That since he has been resumed office only today, after being released from hospital.
Mr. Yali, the standing counsel of the ECI submits that the affidavit on behalf of the Election Commission of India will be filed within a week's time. To stop list this matter again on 20th of 2025. To stop. The affidavit be filed on behalf of the respondent ECI by on or before 3rd of January 2025. The petitioner would be at liberty to file the reply for the next stage.
Right.
Item 40.
Yes, what do you want?
But this is related to non-payment of supply bill in control.
Yes. How much?
50,956.
Are you not paying?
Already a petition been filed.
Order
Already an order.
Who has to pay?
The GMC.
This will be now 49, order dated 5/1/2021.
GMC has to pay. Yes, GMC, why you are not paying?
I will make, to get the instruction, my lord. So there is already an order passed. Yes, they already approved the code and it put an order dated 5/1/2021, page number 49. Then some amount of 1,58,959.
Now, the petitioner herein has approached this court being aggrieved by the inaction on the part of the respondent authorities in not releasing the amount of rupees 1,50,956. It is seen that this court had issued notice on 15/11/2023, but there is no response on behalf of the respondent authorities. First, it is also seen that on an earlier occasion, this court had also earlier occasion, that is on 5/1/2021, passed in WPC number 6404/2014, had categorically directed the respondent authorities to make necessary verification and thereupon to pay. However, as nothing has been done, neither any affidavit has been filed, this court observes that in the circumstance no affidavit is filed on the next day, on or before the next day, this court would construe that the respondents have duly admitted to the entitlement of the petitioner of an amount of rupees 1,50,000 so and so. First of Mr. Edbora, it's the learned counsel for the GMC is given notice to the effect that in the circumstance no affidavit is filed, this court would be construed to pass necessary orders. This matter again on 10th of January 2024. The affidavit be filed on or before 8th of January 2025. 10th of January 2025.
41.
We do should do 1 or 2.
Yeah, 41.
Judgment is also, the are being identified. We are saying AS 01 DC 60, as such nothing else. It's
43.
I may be allowed to withdraw the.
Going to the council appearing on behalf of the petitioner submits that he has instructions to withdraw the instant petition. M. Bora
Transport
MD
Department.
Bora appears on behalf of the transport department. Submits that she has been
Yes, ma'am.
taking into account the petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Item 46.
No case law.
Huh?
The petitioner has no case law.
Fantastic. Tell me why.
If the.
Let us take the advantage of the petitioner
No,
not being around.
let DB there, let DB there.
Tell me, what is it?
The land lordship alleged to be, there is no acquisition process lordship. It was probably lordship gifted to the irrigation department for installment of deep tube well lordship.
Probably.
But I have not received the written instruction, that is why I am submitting like that.
Then why you are saying the petitioner doesn't have a case?
There is no provisions of appointment in the lordship in such a type of.
He wants appointment.
Lord, initially he wants appointment, then he now lordship he changed his. And
Okay,
then
what is his case? What is the petitioner asking for? To pay the compensation.
now he has lordship changed. Initially he asked for employment law.
Where?
Lordship may see the page 15 lordship is depend based on lordship. And extra 2, page 15.
So he's now asking for money. Pay them. Acquire. You have to pay.
I'll go
Day
apply by-
before yesterday, a beautiful judgment has come of Justice Partiwala, I suppose. Delay or no delay has no relevance. You are to pay, pay. And pay as on to. Twice the amount. So you
I
say
said
that
stop.
pay. To direct you to acquire and pay.
Lordship, I'll file an affidavit on tax.
Then why did you say that he doesn't have a case? You admit that he has a case. Mr. N. Upadhyay appearing on behalf of the irrigation department submits that he may be given a final opportunity of filing the affidavit. Court have duly taken note of. The petition was filed and notice was issued on 18/11/2023, but till date, none of the official respondents have filed the affidavit. So taking into account the above, taking into account the submission, this court for the Inch of Justice fixes this matter on 29th of January 2025. The affidavit be filed on or before 2nd of January 2000.
All right.
47.
Yes, what is this?
In 2017, I completed a transportation contract with FCI. That time there was some dispute regarding distance. And they say that distance was not that much as was mentioned in NIT. So they reduced it, I objected, but they imposed a penalty of 25 lakhs. Accordingly, my lord, I have given NDC, matter was closed. Now by this impugned order, they are again saying, no. Additionally, you have to pay 2.11 crore again. This is the case, madam.
Go to arbitration.
Arbitration is not done. FCI has not.
Go to civil court. What should we do?
And our case is that after case, there's a reported judgment of our High Court, my lord.
Huh?
After the case has been concluded, the contract has been concluded. After issuing no demand certificate by the contractor, my lord, nothing can be, no claim from the either side, madam. No claim.
Where is the impugned order?
That will be page 36, madam.
On submission of the no billing certificate in respect of so and so, so and so. So they decided to recover from you. Let them recover.
No,
Why?
they have recovered, that is under challenge. They have deducted this money from my other contract, which they can always do, my lord, under terms of the contract, my lord.
So they have already taken 23 lakh 72,000.
2.11 crore, my lord.
Where?
My lord, that page 36, my lord.
Page?
36, impugn order, my lord. Annexure 10. This is the impugn order, my lord. $25 lakhs was earlier recovered, which I paid, my lord.
And they have recovered this.
They have recovered.
There was no stay.
Without giving, without any notice and all this, not a notice, my lord. In fact, it's a penal order, my lord. Without hearing us, my lord, they have recovered from.
Yes, yes. How do you do that?
My lord, there's an, he has approached the grievance redressal committee and has passed a detailed order. The lordship will kindly.
No, whatever may be.
He was hard.
But how do you do it?
My
Once the
lord,
demand notice comes, what have you done?
The lordship will have a look at the order of the grievance because the lordship has in earlier restriction directed him to approve the grievance redressal committee.
Oh, yes.
And there is an order passed by
Taking
the.
into account disposal of the result, they were given a year to. Hearing and pass. So hearing done.
Yes, yes.
And then passed an order.
Yes, sir.
Okay, this is the submission they have made. Okay. Then
There is a provision in the contract, but if the, after the GRC any dispute remains, you will approach the civil court. There's the provision in the contract.
Then
Page 54 is the order of the POs.
yes, Mr. Chakraborty, what case you have now?
Well, my submission before this honorable court that in the on the fact, my lord, NIT, the distance was mentioned. I had no role. Accordingly, I had done the contract. Even then, my lord, after the contract was completed, they said, no, there is something wrong in the distance. They have engaged the committee. Then accordingly, 25 lakh they have deducted. Even with on objection, I've given this, my lord. They have issued the NDC. Lordship may kindly see, the main point is the judgment I'm placing before Lordship, my lord. On this point, you can see the judgment. It says that, my lord, after, as per the contract manual, my lord, page 38, I have enclosed it, my lord. After the contract has been concluded, after the FCI has fully verified that they don't have any claim from me, that is the contract manual, my lord, they will ask the contractor, now you give your NDC, no demand certificate. Now, the moment it is NDC is given, they release also SD money and everything, my lord. So matter is closed. 25 lakh I have paid. Now after 7 years, my lord, without notice and anything, my lord, they say, no, another 2 crore they have to pay. This is, my lord, culpably.
No, that is okay. That was bad. But by you therefore approached them.
My lord.
You thereafter approached them.
Yes.
Yes. You went there and you submitted all these things that they are doing, but already there is an error in calculation of the distance and all these things. And if you said that kindly recall that impugned notice and refund us the amount. That is okay. Which was rejected by them on certain factual disputes.
Factual dispute is not there, my lord. No factual dispute. Now they say factual dispute is a different thing. simple thing is that from a concluded contract which has been concluded, how can you, after 7 years, the period of limitation is there, everything, how can you deduct it?
When was the contract completed?
My lord,
When was the contract concluded?
concluded on, my lord, on 22nd of July 2017. My case is that
You
arbitrary
took an
necessity.
excess payment. You had taken an excess payment.
According to them, my lord, that's why I'm saying, my lord. Lordship, kindly see that, what is the?
No, did you take an excess payment? That's the allegation.
Lordship, kindly see page 24, my lord. I have no role to pay, my lord. 24, Lordship, kindly see.
Yes,
It is their mistake and everything. I have already paid for their mistake.
yes, where?
The NIT, my lord. Page 25, I've given the type copy, my lord, it's not clear. Ex railway siding, Chamshari to Tongla, 90 kilometers. It's mentioned in the NIT, my lord.
Mm.
After I have completed, they said, no, it is not 90. It should be 76, 74, something like that. That impugn order that mentioned. They said, you have to give us 25 lakh. I gave objection, but even then I paid it. 25 lakh. Matter was concluded.
25 lakhs for what?
For this, they are saying that you have taken excess money because the distance is actually 76, not 19. They are
So are you, for 14 kilometers, it is just 25 lakhs?
no. My lord, they have, it is their, I have not done anything. They have, it is their 25 lakhs, they have quoted, my lord.
So once they have quoted wrongly, so they cannot quote again.
Possibly, every time, my lord, they possibly cannot do with 25 lakh they have given, and NDC is, after NDC is,
So whether you have taken excess amount or not.
no, it is their 90, 76, it is all, they are, I don't know, my lord, they are saying all these things, my lord, they, employer committee goes, no, earlier it was a mistake in NIT. NIT mistake, my lord, how I may be held responsible, my lord? I have quoted my price accordingly. But even then, one punishment I have taken, my lord, 25 lakh. Now again 2.11 crore. Now 7 years, after 17 years, they'll come, no, another 5 crore you pay. That arbitrariness I'm saying, my lord. How long they can go, my lord?
Then last time, why did you go away from here?
My lord.
I never said that you must have gone away from there, that we will go there. For a demand notice that
said-
if it fails to deposit the amount, the same would be recovered. Mr. Chair submits that the petitioner presently has various contracts with ANSS. The demand so imposed would be illegally recovered from the running. So as on the date passed by me, they did not recover. Because that is your case, which I've recorded in my order of 17.8. We come back at 2. Page 44.
It's an eviction method. Item number 11, it was called up by, it's my mistake, my lord. Because these to fix after 6 weeks.
So?
There was an interim order, was.
How can I? Ask the order.
Kindly, my lord, that maybe it's an eviction matter.
So what?
I,
Get
my apol-
evicted. After getting evicted, then the client will know.
but I'm sorry,
You
extremely,
have responsible counsels.
extremely sorry.
After order, let's. Yes, Mr. Chakraborty.
Much obliged.
Your lordship is correct, my lord. After your lordship order, my lord. After GST report, they have deducted, my lord.
When?
My lord, I've enclosed the orders of page 59 to 64, my lord. On 2nd of January, a few days, my lord, GST order. 13 days, after 13 days. I approached on 4th. Page 59 to 64, my lord.
So you are challenging these orders.
This order along with that demand notice. Or
The demand notice is okay. This court, I am not going to touch on the demand now. The question therefore would be, can you make a recovery from others?
Actually.
But did you raise the issue that after 7 years you have done this?
Before GRC.
Before the GSU? Mr. Roy, under what provision you have deducted from the other year?
Hello, there's the permission to contract. About the also kind of the contract, original contract copy, but it was not there in record. My lord, I have paginated it for your lordship convenience, page 13 at the top, my lord.
This was the contract entered into between.
That's
Show me that. Which
page
page?
13 at the bottom, my lord, Roman 14. Any sum of money due and payable to the contractor, including security, the fund is not very legible, so and so, under this contract may be appropriated by the corporation and set off against any claim of the corporation for payment of any sum of money arising out of or under this or any other contract made by the contractor corporation.
So was these contracts with which the petitioners were engaged
If
were
there
in
is a-
existence at that point of time?
My lord,
Were these contracts in existence from when you have now deducted this amount?
God,
Then-
contract is any other contract.
So any
any
other contract made by the contractor with the corporation means it presupposes that there is any other contract which is there. Isn't it?
It doesn't say it's in existence, or any other contract, it may be previous contract. That is
For
not,
previous contract.
Yes.
So can it be for future contracts?
my lord.
Can it be for future contracts?
In every contract, my lord, in the contract from which we recovered, there was a clause. In every contract,
No,
there
but
is-
you are not doing it for those contracts.
my lord, I
You are
am
not
saying
exercising the powers in respect to those contracts.
because we had dues, he had, because some payments were not made to him from those contracts. So the contract subsides.
No, but
Payment is
whether
not
those contracts were in existence,
existence because the payments have not been made.
no, were
Fine.
those in existence at that point of time when this agreement was
Yes,
entered into?
because there's a money not paid completely, contract is not ended by paying in money. Contract, contract is in existence because the money remained to be paid to him. And I think, you know,
Kindly see page 60 of the writ petition.
six zero, you know,
Yes.
yes,
This is the contract from 18/7/2017 to 17/7/2019.
that is the future contract.
Future.
That is still existing.
No, maybe. But I'm not on that. I'm saying as on the date on which you entered into the agreement. Here there is no use of the word future contracts.
It says any contract.
Any contract made means there is an existence of contract.
Without existence contract, even the present contract still exists. Present contract has a term up to for 2 years. It is for 2 years. So on 2017 we 2015 the contract started, and 2017 it's up to 2017. 2017 itself we made the demand notice to him, and then this contract was extended. This particular contract was extended because the next contract was not entered into. So it was given some extension. So he was still there. And since the payment is made by mistake under the Contract Act, we can make recovery. The provisions of section 72 of the Contract Act, we can make recovery. And
No, Mr. Roy, there is no quarrel that you cannot make a recovery. But can you make a recovery beyond the period of limitation?
what is the limitation, my lord? I don't, Lordship will kindly have a look at section 28B of the Contract Act.
What is it?
There cannot be any contract, my lord. The provision, we cannot read the contract that debarring a party to making recovery after a particular time. Section 28B provides that.
What does it say?
Contract Act, Lordship kindly have a look. We can, my lord, 28B.
No contract is-
That cannot be, you cannot read this particular term and bar of limitation in a contract. It will be,
Yes.
it will be a void contract. If there is any such provision, we can read, and there is none. My lord, will kindly have a look, which says that every agreement B which extinguishes the rights of any party thereto or discharges any party thereto from any liability under in respect of a contract on expiry of a specified period, so as to restrict any party from enforcing any rights. So we cannot restrict a party from enforcing right to make recovery. And section 72, my lord, kindly have a look, 72 of the Contract Act. 72 of the Contract Act.
No. 28 is in respect to agreements in restraint of our legal proceedings void. There's no question that you cannot have a contract that there cannot be any legal proceedings. You cannot have a contract. But can you say this to mean that even when the law of limitation also is a substantive piece of legislation?
Says what? I cannot bring an action. It doesn't say I cannot make recovery. Limitation Act only restrains me from bringing an action against it in a court of law. It does not restrain me from making recovery from it. That is my humble submission. So it is a payment made by mistake. Section 72 specifically says he is bound to make recovery. And it is an admitted position that payment is over payment in excess of the terms of the contract. Payments, what happens, payments to the contractor are made on per metric ton per kilometer basis. Now, the dispute is, it is the contractual dispute basically your lordship is raising in a 256. Contractual, terms of the contract. He is trying to, place a case so as to, lordship to interpret the terms of the contract. I don't think, lordship in a 256 would like to interpret the terms of the contract and contract.
No, no,
And in fact,
Mr.
what
Roy,
happens?
no, Mr. Roy, this court is not going to interpret the terms of the contract. No. The question is, this court will look into the fairness of the decision. Fairness of the decision is, fairness of the
Now,
decision
it
is
happens
that
like this.
you know that you are not in a position to get recovery in the manner as per otherwise permissible under law. So therefore, what to do? You recover it, use the other amounts which as per this contract, this term is there, so you use it from other contracts.
There are some admitted facts. The Lordship kindly have a look at one paragraph of the GRC order, the final order, which is written, final order. Page 54 is the order. This dispute was, my lord,
Page
54, my lord. Petitioner's case, my lord, page 56. Petitioner's case, my lord, page 56. Hearing of the contractor. The Lordship got it, my lord. 56, my lord. The contractor was heard at length on 6/11, and the contractor reiterated what he has stated in representation dated so and so. Further, the contractor during the course of hearing by GRC submitted that restriction of movement of heavy vehicles on certain stretch of road from Changchari to Tangla was imposed by the state government authorities, and it caused movement of heavy vehicles trucks via longer road, and distance of this road from Changchari to Tangla was 90, which was duly mentioned in NIT and other documents relating to and so. However, the contractor did not produce any such document substantiating his claim of restriction imposed by the state government authorities during the contractual period 15 to 17. He also did not say as to whether the restriction as claimed was for the entire contractual period or fraction of the said period. The contractor submitted that he may be permitted to give additional representation or submission of bring on record the fact of restriction imposed by the state government so and so. In view of above submission, the contractor was given opportunity to GRC submit additional represent submission of any within 5 days. Now, my lord, GRC order, page 67. The hearing by GRC on so and so was attended by DGM Region Assam. It was informed by the DGM Region Assam that the matter was taken up upon receipt of CAG audit so and so. The contract has not disputed the distance of Changchari to Tangla as 76 kilometers, nor has he submitted any document or the state government authorities showing, enabling, indicating that there was a restriction on movement of heavy vehicle on any stretch of road from Changchari to so and so. In absence of the same, it is not in dispute. The distance sanction is 76. Now it is not in dispute that the rate quoted by the contractor 793 per metric ton per kilometer. So my lord, if it is per metric ton, then beyond 76, if it does not travel, there is no question of per metric ton. He cannot get the money which is not transported. Because if it is 76 factually transported, he cannot get under the terms of the contract any for trans. There is no question of transportation. There is no load here. So that is our, my lord. So he cannot get it. This is, and the payment was made on the basis of 90. Because it factually he did not transport for 90 per metric ton per kilometer. If you had metric ton 90 kilometer per metric ton, then the case would have been different. There is no loading truck. Payment is made on net weight, not on empty truck.
So there is no dispute to the fact that the distance is 76.
That's right. That's right.
There's no dispute to the fact that he has received amount for 90.
Right. Exactly. Exactly.
There's no dispute to the fact that there are clauses in the agreements whereby you are permissible to recover.
That's right.
The only thing which is in dispute out here by the petitioner is to the fact that a claim which could not otherwise be permissible under law to be recovered is being sought to be recovered by way of these means. That's your case.
And when the contract, the terms of the provision says, first you'll go to the GRC. And if there is still other dispute remains, then he should go to the civil court. That is the provision of the contract, not before a launch.
Yes, Mr. Chakraborty, tell me.
Well,
Why is it unfair?
After GSC, I can come to court. Civil court is not mentioned. But I'll come
Not
to-
necessary. You have come to this court.
Yes, my lord.
So we
Now,
will
Lord, may
put
kindly
a
see
full stop to everything. Yes, tell me.
that, my lord, that NIT has mentioned 90 kilometers. I have completed the work. After completion, they hold a meeting and this thing, they said that.
No,
we
do you
want-
have any evidence? Why didn't you produce any evidence that it was more than 9? It was more than 76?
No, I'm not going to that aspect of the matter, my lord. What I'm saying, my lord, they have passed an order saying this is not 90, this is 76. I gave my objection. Finally, they said that you have to pay 25 lakh rupees for that. I paid the amount. It is not that it was not there in their knowledge. It is not that I have overdrawn money. It is their NIT. They have paid. Subsequently, they have rectified, said, no, 90 kilometers. We have measured it now, it is 76 kilometers. But it is not.
No, you are not denying to the fact that it is 76.
76, that time I denied, but I said that there was road restriction.
Now you admit to it.
So
that-
finally, my case is this, madam. Finally, I have paid the amount, 25 lakhs.
No, whether it is 25 lakhs or more, is the, are you
Now-
saying, no, are you saying that an amount which you are absolutely liable as per taking it as 90, 70 say, is only 25?
No, it is their calculation.
No, 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 I'm asking you, you have received the amount.
I have received the amount, my lord.
So as per you, because you are coming under an equitable jurisdiction. If you are coming in an equitable jurisdiction, this court also has to exercise that jurisdiction on an equitable basis. Now, can we say now that 70, you admit that it is 76? Are you saying that 25 lakhs is the excess amount you have received? Nothing more than that?
Well, this 25 kilometers, they have calculated.
I'm not asking that. I'm
But that
asking
I have
you
not calculated.
whether
My
they may tomorrow say, no, it was more than the 5 crores also. They may say. It is a question whether the amount is 5 crores or not. Now, are you saying, from your estimation, that it is only 25?
And my statement in the writ petition is that whatever they said, they have deducted. 25 lakhs, they have deducted.
No, no. I'm saying, did you receive?
For that calculation, what your lordship saying that there is a distance of, difference of 14 kilometers, 76 and 90. The 46 amounted to 25 lakhs or not more than that. That calculation I have not made.
You have come before this court and
No,
you
no,
have not
no,
made
my
it.
lord,
How is it possible?
I have fulfilled their demand, my lord. 25 lakhs they have deducted.
No, 25 lakhs. It may be 5 crores. Tomorrow they may deduct more if they find more. But the question, therefore, if they deduct more, then the question of unreasonability aspect will come in. But the fact is, have you said that it cannot be 2.3336 crores? If we take it that 9.13 is the per metric ton is the amount, and I have not received an excess payment of 2.336 crores. Is it your case?
No, no. My on fact, I would say, my lord, it was mentioned 90 kilometers. I have given the bill, 90 kilometers. I have drawn. At the end of the contract, they corrected themselves. They said, no, it was an error. So we have calculated. Now you have to pay 25 lakhs. That also they have deducted. That was closed in 2017. My very important submission would be, my lord, I'll be placing my judgment before lordship, my lord. After the NDC has been asked for, I'll go to the clause, my lord. It's a totally legal point I would like to raise, my lord. Thereafter, they cannot say, again, reopening the contract and saying, my lord, 72 is not applicable, my lord. I'll read it, my lord. After that, the 72 of the contract that they said, my lord. Can you read? 72 is what, my lord? Liability of a person to whom money is paid or thing delivered by mistake or under coercion. Coercion does not come. Mistake. My lordship, kindly see, having rectified the mistake, they have already did it before closing the contract, 25 lakhs taken. Now, the instrumentality of the state, my lord, can they go? Go on. Now they have said, my lord.
But is it your case? Therefore, I'm asking you, is it your case that under no circumstances it can be 2.36 crores? My simple question is this,
While coming to the read petition, I have not gone to that.
then you don't have a case.
I have not gone to that, that cannot be 2.11, but 25 will suffice for that.
No. If it is the amount of 2.36 crores is the amount which is you are liable to pay for our having received in excess, this court is not going to interfere. You have to categorically come and say that, look here, the amount as per my calculation should have been this amount, which they have now been doing it without any authority because they could not have taken it more than that.
It's 6 years before it happened. I have only said that the distance was calculated taking into account the road diversion, which they have also.
Which you failed to prove. Which you failed to prove.
Yes. That. Now, as I said, my two things, after 6 years, whether they can come up, just deducting from other, they can do it after 6 years, they have explained this.
They have recovered it.
The delay, the way they have corrupt.
No, they say they went to CAG.
CAG has said we have deducted. That's why,
So CAG has said they did it. Therefore, I'm asking you, is it your case that it could not, under no circumstances, I have received more than the amount of 2.36 crores is wrong? That's not your case.
That I have said, in the way I said that, while calculating the distance of 90 kilometers, that time.
But that you have failed.
That was.
No, Mr. Chakraborty, that you have failed. Because they have looked into it, have heard all these persons concerned and found out that you could not prove that there were the prohibition and movement of the trucks.
So, your lordship is correct, that there are two legal issues. First thing I have said about the limitation part. Second thing, lordship may kindly see one
part, as Mr. Roy said, categorically so. Say, the limitation is only in respect to filing of suits. It's on filing of suits. Not, it does not say that you cannot enforce your right under 72. Maybe tomorrow if they file a suit enforcing the right under 72, they may not get it. But therefore your case, which I was asking here, is whether without filing a suit, can you do it? They say, yes, we can do it in view of clause this of the contract.
But that your lordship pointed out, my lord, this contract, these are subsequent contract.
13. 13. They say about clause. Clause 14, set off.
Okay.
So they say that we can recover it from other contracts.
That contract, as your lordship.
But that contract term is not under challenge.
That contract
term is not under challenge.
My lord, lordship has pointed out one thing which actually did not come to my mind also, that whether they have deducted from a contract which was in vogue at that time when this contract was signed. These are contracts, all are future contracts. So that time, this contract does not mean that all future contracts anywhere.
That's not your case in your pleadings.
That I feel, but it's a legal issue can always be
That's
taken.
not a legal issue. That's an interpretation of a term of a contract. You therefore have to challenge. You have to therefore challenge this thing that you cannot exercise this power. Is it your pleadings anywhere?
Page 38 may be seen for a moment.
Yeah.
This is my second. On the basis of this, the judgment has been delivered, my lord, against FCI effects of the same parties, my lord. Your lordship kindly see, this is the storage manual of FCI, which is part of GCC, my lord, being followed in all contracts, my lord. Refund of security deposit. Now, the security deposit taken from the contractor will be refunded to him on satisfactory completion of the contract in all respects, on presentation of an absolute no demand certificate in the prescribed form, and on return of the goods and condition. So this is done. 29.2.1 may be seen, madam. In what situation NDC is issued and called for, madam? The following points are relevant relating to submission of no demand certificate by the contractor for releasing so and so. If the corporation has no claims against the contractor, a no demand certificate from the contractor should be obtained before releasing the security deposit. If the contractor has claims against the contractor which are required to be adjusted against the security deposit of the contractor by following the usual procedure if issuing show cause notice, etc. There is no question of asking the contractor for no demand certificate. Now, if after adjusting
Mr. B. Chakraborty, kindly listen one thing. These terms which are being made, the GCC is always subject to the special conditions of the contract. Now, the contract categorically says that they can set off. How do you take care of that situation? That's the law.
Why I placed this? service,
Yes,
sir?
this is a GCC. The GCC is always subject to the special SCC.
There is a
Now,
special-
SCC is also further subject to the contractual terms. That's the law.
Now, my lord, if any due is there of FCI can always deduct it. Not, it is given, my lord. If the security deposit does not cover the due, he can take from other contracts. But my submission is that it's a contractual relationship between petitioner and the corporation, my lord. It says that when the FCI makes the calculation, says that I have no due against the contractor, then FCI accepts the contractor, you give your NDC now. After NDC, everything is released. So my only submission is regard that in a contractual area, my lord, once its contract is closed, after following this procedure, my lord, hereafter, none of the parties have any claim. Now, here in the judgment, I'll be placing, my lord, the same thing happened, my lord, in the Shillong case. I claimed something after the contract was over. There, FCI has filed a affidavit saying that after NDC, you cannot do it. The matter has been closed. So that has been relied upon this judgment, my lord. And therefore, the reported case, my lord.
This judgment was taken in appeal before the division bench. And division bench also allowed, but then Supreme Court finally said, go before the DRC.
No, my lord. Yes, my friend is correct, my lord. Division bench has not interfered the judgment. Supreme Court has also not interfered the judgment, but Supreme Court added an observation that to take this dispute to GRC. But on merit, this judgment was not interfered.
And said the GRC would not be influenced by the observations made. Everything. Supreme Court has had, while sending it to the GRC, said GRC will independently decide without being influenced by any observation that it reported.
Any observation. So, but in the now in that case, my lord, that case, the other case came to GRC. GRC has not gone to NDC, my lord. They have again given this and that, and GRC, this point is not decided, my lord. Now, again, this is before lordship, my lord. My submission is two only, basically. Basically, if the two, my lord, that limitation period comes in the way.
The limitation period will only come for recovery if they file a suit. You see, section 3 starts with that no suit shall be filed, appeal preferred, application made beyond the period of limitation which is stipulated of the industry. That's the law.
Well, if the, after closure of the contract, even if they have some dues, then there are remedies, my lord. They can approach civil court and say, get it, my lord, filing it. There are remedies, they are not remediless, my lord. It's my submission only.
You have also the remedy.
Every
You
time.
also have the remedy. Go to the civil court.
Now,
Express your things.
Limitation Act says that for a government action, 30 years time is there. That was Article 112 says.
They are not government.
They are not government. Mal. There is a judgment of Supreme Court. They said that this clause is not available to a corporation. So after that period, they cannot take that 30 years time, my lord. Any time they can come and my lord.
So but they have a clause in the contract, so they are doing it.
And there is an issue of double jeopardy, my lord. Once for the same cause, they have imposed me a cause. How they have quantified and all, my lord. There, I have no role, my lord. Again, after 6 years, my lord, another, my lord, 2 crore. Now, after 17 years, they may come another.
Double jeopardy applies to contractual laws.
No, I am in the field of read jurisdiction, my lord.
But then also read jurisdiction, if you are asking, would it apply if it is not a criminal matter?
My lordship may consider this from the point of view of the arbitrariness on the part of FCI, my lord.
No. Therefore, to say to be arbitrary, you have to therefore say that you see, this was the amount of 25 lakhs which was there, and I have duly paid, and they are not entitled to a single more penny. But if you are taking the fact that
That I say-
no, now period of so and so is gone, as they have given me this particular certificate, they cannot reopen it.
But that, Mano, there may be another eventuality, my lord. They may come, they know, no, this calculation is wrong. Another 5 crore you have to pay. They may come after 17 years, my lord.
Yes.
My lord, it's a field of contract, my lord. They are contractual
So
liability.
therefore, you have to therefore say that this is the amount which he is not entitled to, but not on the technical aspect. You see, we are exercising 226. Are we to just lose sight of the fact that you have taken an excess amount of 2.36 crores?
My lord, or fact, my lord, realizing the fact that I'm in a rich jurisdiction, my lord, the factual things I did not read, I've taken only pure legal. No.
I've seen your representation. You never raised that issue to the effect that amount is not 2.36 crores. It could not have been taking into account that this is the amount I have received it for 90 kilometers, and it is 90 kilometers, not 76 kilometers.
No, I have only said that
The fact that it is 76 kilometers is not in dispute now.
my lord, they have their own mechanism to measure distances.
So if it is
I
a
cannot
question
be
of
a party to this,
mechanism,
my lord.
otherwise prove it before the civil court that look here, this is 76, is actually 90, not no, actually I should get more, it should be 100. Prove that.
My lord, their mechanism, I cannot be a party to this. Let's say they no, no,
Be
you
a
are
party to
wrong
it
and
by
I measure
proving
my
it.
own way.
You have been given additional opportunities also there, as you can see in the order.
My lord, that is all that I have. My lord, it is too
What do you want? Dismissal? Or
before vacation, it will be shocking, my lord. And, but
no,
I
no,
think you
don't. Doesn't take much. Today I'm free. I've finished almost most of the matters are over. Dismissal or go to the civil court. Before vacation, that is why I'm giving you the exceptional or very magnanimous thing to that effect, that you can go to the civil court. Dismissal. Because this is the case, why should this court exercise 226 now? Taking into account that there is no dispute that you have taken an additional amount of 2.36 crores, if they want to recover, why should this court interfere into this aspect between your fight?
My lord,
What is arbitrariness?
Sir, kindly see, if fixing the distance as 90 kilometer and the NIT, I was not a party, I was nobody to say anything. Again, in the exercise of making a calculation,
But you have accepted that.
No, I was not a party,
But you have accepted that 76 being made.
that acceptance was that time when it was closed. my lord.
Whatever may be, you have accepted 76.
Hello.
So therefore, there is an additional 14 kilometers and you have received that amount.
My lord, that order, how it is 25 kilometer, that one indication has been given. Lordship, kindly see that order, that why it is, Lordship, now, my lord, why it is 25 kilometer only, my lord. That is because they have taken a conscious decision that page 31, Lordship, kindly.
No, you are not challenging that.
No. Well, possibly when the last kindly see, my lord. Last paragraph, as your lordship got it. Page 31.
No, I've looked into this, but you see this order, the final order, it categorically says how they have arrived at. Kindly see, they could not find out anything. Kindly see hearing of the AI being done. Kindly see page 57. This is how they came up. And said 76.
57, madam.
57.
Paragraph 6, my lord.
Six 6.3.
Yes.
It is not in dispute that the distance from Sangsari to Tanglai was 76 kilometers.
Yes, my lord. It
It
relevant.
is also not in dispute that the rate quoted by the contractor was 9.13 per metric ton per kilometer and the contract was awarded at a rate of 9.13 per metric ton per kilometer. As regards the issue of delay in raising the demand notice was issued pursuant to so and so.
Now, this as regards this 76 kilometer, my lord, why it is 25 lakh that time now, why they are now increasing, that is their pay
No,
cut.
this is what the cake says.
Tax is, what tax is different from them, the page 31 basically. As you can see now, there's last paragraph, the penultimate paragraph. In the light of above facts, competent authority hereby directed that the bills of the transport contractor may be passed on the basis of 76 kilometer with effect from 29/4/17, period from which the distance was verified and established by the to be decreased. So from the period it was detected that it is not 90, it is 76, it is to be recovered from that. Now, CAC says, possibly, my lord, I think I've come across, CAC says that no, if that is so, take from the beginning. That is why it's done. It was 25 lakh, now it is 2.42. Now this
So
is
this fellow was wrong, the assistant general manager. You have taken the money on the basis of when it is 76, is 76.
one of that wrong one after another they are committing, my lord, and ultimately anytime they come up and say that we paid it, first in issuing the NIT, then again recalculating, then again
Mr.
imposing this.
Chakrabarti, we can do you a very good favor. We can put a full stop to 2.36 crores and nothing beyond. And I hope Mr. Roy would not oppose that. 2.36 is the final amount, no further more. Are you going to further charge another 5 crores?
Yes, that's fine. Now there is no more to be recovered. There is no more to be recovered.
See, you're saying from the future agony because of coming to the High Court.
No, they correct their mistakes very frequently, my lord. You are lost.
No, so they won't,
Very frequently
further,
they
they
won't
won't
correct their mistakes.
further correct. I'll take it as his submission that this is the one and final amount, no further amount. This arose because of the fact that there was direction for this period, which makes it.
Not my lord, few lakhs, it's in 4, my lord. Lordship, kindly see, we,
Crores for FCI is too little.
for
A
FCI,
contra-
not for FCI contractor.
No, no,
my lord.
contractor, FCI contractor, crores is minimum.
I was regularly doing it, I have stopped doing it, my lord. Now I cannot.
I was also an advocate for those, the contractors once at for time. For them, FCI, doing FCI contracts is the most good thing one can do.
Maybe, my lord, 2017, I was happy, it was very profitable. Now, it after 2023, I understand it was a total loss contract, my lord. Now this
Why
demand,
didn't you make out a case in the civil court to that effect that you quoted 9.13 taking into account the 90 kilometers? And therefore, now they have drastically made it 76 and recovered all these things in this manner. My rate would have been much more.
yes,
Take
my lord.
all these things. Take up all these issues before the civil court and do it. Why are you doing it out here? See, now the reducing of all these things now, because you see, now we've got a cause of action. In view of the fact that I passed an order earlier, I'm asking you to go to that thing. From there, now you have to come up with this 76 thing. Now, the question that you quoted 9.13, taking into account that in the tender it was 90. And as such, the rate would be much more if it is taken as 76. You would have taken it on the basis of your profit making. So you want to make out the case out there. But not in this.
Can
Now
I
you
have-
cannot say,
Yeah, I
now you cannot say that it is not 76.
My lord,
You cannot say now that it is
no, I
not
cannot say, that's
76.
why, my lord, I am not arguing on that line.
So therefore, what you can say is that you put in 9.13 on the basis that it is 76 or 90, whatever may be. My quote was this, taking into account that this was my. But now they have taken this decision.
It is my case before lordship, my lord.
No,
And
this is
on
not
record,
my,
lord.
this is not the case before me, and that cannot be proved without evidence.
No, my lord,
And
that-
the chief has not
but I-
given me any election matters also to have one of those podiums. If he had given, then also I would have tried my best.
my lord, I'm just placing before you lordship, my lord, ABA International has said, my lord, what can be in a writ jurisdiction in a contract matter, what can be treated as a disputed question of law? merely because respondent jumps are saying that this is disputed. area
No,
cannot be-
that is not the question. They are not saying anything. They are not saying anything disputed. They are saying nothing is disputed. It is 76 kilometers. They've taken in money at 90 rupees, 90 kilometers, which therefore the difference is 14, 9.13 per metric ton. For 14 kilometers, they have taken in excess. And as such, the amount initially was 25, taking into account from the date it was shown as decreased, it was done. But in view of the CAG's information, it has to be taken from the date they have first received. And therefore, as we have paid more money by mistake, we want to recover under 72, we have recovered as it is permissible under the set off which is given under 40. That is his simple case. I am not disputing. But your case is, look here, I quoted this 9.13, taking it to be 90 kilometers. Now you have abruptly made it 76. Now, how do I sustain myself?
Yes, this is my case.
Now that is a question which has to be proved.
This some time for my lord. My lord, maybe part of my lord, taken up after some time, my lord, that I take clear instruction from my client.
I can give you one opportunity. Bring this on record by way of an additional. He let him bring on record. On hearing the counsels appearing on behalf of the parties, this court had pointed the query upon Mr. P.K. Roy, the learned senior counsel appearing on behalf of the FCI, as to under what provision the amount has been deducted from other contracts. The learned senior counsel has drawn the attention of this court to the contract, the model tender form for the contract in respect of which was awarded to the petitioner earlier, which is the subject matter of the instant dispute. Full stop. Taking into account that the same is not a part of the record. 7 days time is given for filing an additional affidavit bringing on record the said contractual document. Full stop. List this matter on 21/1/2025 for further hearing.
Right.
Yeah.
Please, I have 1 week time to file our affidavit, lordship. It is ready, lordship. Or 2 days time.
Huh?
Affidavit, lordship.
What is wrong with your government? Why do you require so much of time to file affidavits? 5/8/2024, I made it very clear. Mr. B.J. Talukdar said that I'm going to bring on affidavit within 7 days. Then I fixed the matter on 9/9. Thereafter, the matter has not come. Now we are in 9/12, we even crossed that. Who is the great officer who has not given any importance to the notice being issued by this court? What has happened, Mr. Monto, in your case?
Well, after this, they have not responded. Every time it comes, they pay for time. Now, enough time has gone.
Setting aside and quashing the order issued by. What is this order you are challenging?
I am challenging the order whereby my contract, the transportation contract has been cancelled and the security amount of 10 lakhs has been forfeited. This is the cooperative society. That's what I think.
This one, 26th of June 2024.
26th of June 23. It's of June 23. Without any evidence, nothing, only on surmise and such. Let the conjectures, they have penalized me, although I have done my part. They detected the anomaly in the godown of the GPSs.
Was it preceded with a show cause? Show
The
cause.
proposal was given to me.
And you have given a
And I
reply.
have replied, even in all documents, nothing has been discussed. Those are not at all taken into account. 71, that letter of so forth. I have given the reply, page 72. I think every.
Here the conclusion is whereas MS Namrup had not distributed the TDS onward to the beneficiary
Yes.
within the government stipulated time from Iman to Iman for May and June so and so, that is the date of inquiry. A part of May quota and the whole quantity for June quota is believed to be diverted in open market.
Yes.
Are you filing the FIR?
Yes, sir.
Yes, so fine.
Because FIR is filed.
How have you found out that this has not been done?
Lordship, there was a statement given by one of the GPS person, Lordship, not distributed. After inquiry, Lordship, there was an inquiry made.
Did you give him the copy of the inquiry report? Because your show cause does not say anything.
No.
Whereas the inquiry conducted by a team of so and so, it is detected that the secretary and other officers of AR are involved in malpractices and diversion of highly subsidized so and so, as so and so.
Not here, Lordship.
We go as per the doctrine of non-traverse and hold it that this is bad.
This time may be given, Lordship.
No, no, no.
Ready, our estimate is ready.
You hold it that this is bad.
This is entirely, my lord, without any
This is arbitrary
very arbitrary.
and there is no response. And there, you do not show that you have looked into the inquiry. And Mr. Monto, where this inquiry reports given to you?
No, nothing has been mentioned here. Only what it says is.
No, no, no. The fact is that in your representation, you have not stated.
It was not given to us. What we say.
You should have taken that plea.
No, about what it is to the so-called that is to 71. This is what has been said, and I replied to that notice on.
You have not asked for the inquiry report.
No. This was given and we have given everything on that. That this is how I have dealt with. Because kindly see, well, facts are like this. It's 2-tier contract. I have to first lift it from the FCI, then to deposit it in the CPSS godown. My part is over. Then they will have to issue again memo to me, giving the direction to deliver to respective GPS. I mean the doorstep shops. When I get it from them, I again take it and give it. The schedule is to be maintained by them. It is followed by them. So I did it exactly what allegation is that the first year I did it and delivered it. In the go down, they found certain things and say that I may be.
No, that is not the allegation in the response. They say that some inquiry was done. From their inquiry, it revealed that you have not been actually giving to the FPS dealers, but what you have done is you have sold it in the open market.
Now, I have in turn, I have in my show cause, I have shown those documents given that they have issued receipt, that authority has PSS has received it, and they have given me, but subsequent second trial, that allotment was never paid. This was my case. And they have given. I have placed here also these documents. They ought to have discussed everything. They have to have gone through and find out what is there. It was not in my position. Had it been during the transport itself, yes.
Now this memo is issued by whom? The secretary?
Memo will be issued by the GPSS secretary, President.
That is you.
Sorry?
Your secretary is you.
Okay.
Who appoints?
Is the deputy commissioner appointed. And
Secretary is being appointed by the deputy commissioner. No.
contractor GPSS. I'm a GPSS, but a contractor for another GPSS. This GPSS, I'm a Larua. I'm the contractor. I deliver it to Namrup GPSS.
No. Who takes from the Namrup GPS to
I am to carry it from the FCI and give it to the Nam.
your work is finished there?
Yes, first year is over.
From there you do not send it.
No.
No,
Then
you
again
say
they will
that
have
you
to
send
allot
it.
me.
I kindly see, yeah. Page 74. Paragraph 4. So as you know, the government had instructed to lift and transport the rice against April and May and June quota in a very short span of time, for which we were very much involved in completing the instructions from your office to avoid lapse of the allotted quantity. In the meantime, we were in continuous contact with the Secretary of Namrup GPS to issue us the program and memo, since we were not authorized to issue memo and transport the rice to FPS without memos. So your duty was also to the FPS also.
No.
So
yes,
that we can place our vehicles to complete the vehicle delivery at FPS memo tier 2. But the Secretary of Namrup did not turn up our request, nor they informed you about so and so.
Yes.
The Secretary of India had been doing the same in the past year, so you are blaming the Namrup Secretary.
For their duty to allot me first and foremost. I told them, you have not done it. They said, we are doing it. So they themselves did it in their godown. Unless they issue me that memo, I cannot lift it from their godown and distribute it to the FPS. They will have to give it. This is the procedure they follow. Second tier, they will have to issue me the memos to be given with the list of the fair price source that you deliver it to them. Then I take it and deliver it. So my plea was that they never did it. I took up the matter that you do it. I pointed out.
Yes. List this matter again on 19th of December 2024. The council, appearing on behalf of the respondent, submits that the affidavit would be filed on or before 18th of December 2020.
Let the name be recorded so that someone will take responsibility.
The name recording does not, Mr. S.S. Roy. Earlier, I have recorded Mr. B.J. Talukdar having.
Earlier to that,
Please
Mr.
observe that on
SK was there.
Mr. A.K. Mohanto, the senior counsel, has expressed urgency in the matter and further submits that enough time has also been granted to the respondents, but they have not filed their affidavit. Mr. S.S. Roy, the learned counsel, submits that within 2 days, by 18/12/2024, the affidavit would be filed. So list this matter on one.
49.
May it please your lordship. Grievance of the petitioner was of illegal eviction from the Tauji land which they were in occupation, possession.
Have you been evicted?
Yes, your lordship, but
What
as per
means?
the instruction given by the respondent number 4, that is the circle officer, office of the circle revenue office, they have admitted this part that illegal eviction has been done.
Where?
Your lordship may peruse the orders, your lordship. Is admitted by them that no notice was issued before eviction.
Where? No, you were evicted from what?
Was it Tauji land, your lordship?
The thousand land is government land.
It's true, but
What
due
business
procedure
you
of
have?
law should-
Huh?
Procedure of law, they should give us notice.
Have you been evicted or not?
Houses were sealed. your lordship. I have been thrown out from them.
So nothing means, what do you
I
mean?
will be restored until unless they should take out a procedure, your lordship.
Procedure will consider next time whenever you come before the court. What right you have over the land? What right you have over the land?
Lordship, I am on the, over that particular, from my ancestor, your lordship. I have submitted the Jamabandi also, your lordship.
And
Page number 80.
page number?
80.
What is your name?
My name, your lordship.
Baharuddin.
Fokuruddin.
Baharuddin.
Baharuddin is the son of Moinuddin, your lordship. He died.
So your name is there against what?
Johoruddin, your lordship, my father name.
This is a patta land. How do you say this to be the government land? This is Exona patta land. Then Exona patta land also you cannot be evicted.
Without any notice, I have been thrown out from that property, your lordship.
Yes, madam, why?
Lordship, we have received instructions.
Huh?
We have received instructions.
What does he say?
Just said, the weekly budget has been settled a bona fide, a plot of land measuring 2 bighas, 2 kathas, 8 places covered by that number 412 is.
414 and 415.
But the Kultali weekly budget located under Odali Anchalik Panchayat bearing that number 414 and 415. Not 412.
Then
Why I have been thrown out, your lordship.
her land is what?
412, your lordship.
412.
But
But the petitioners mentioned that Kultoli has been settled at the bona fide settlement of a measuring 2 Iman covered by dark number Iman and Iman Pata number so and so, which is and not true. Whereas Kultoli weekly Bazaar has been settled from so and so is situated at the south of land of so and so 414 and 415. Now the question is, did you evict them from 412?
But they not enclose any eviction notice, eviction.
That is their case, that without doing it,
But
file your affidavit. Let the circle officer file an affidavit. Who evicted them? Who has evicted you? Circle officer. Okay.
We have not received any notice, ma'am.
The circle officer, Lanka Revenue Circle, is directed to file an affidavit before this court on or before 21/2015, 25, 22/1/2025, as to whether the petitioners have been evicted from the land under dark number 412 of annual patta number 43, situated at village Singh, Gaon, under Kaki Moza, Lanka Revenue Circle. This is the matter accordingly.
If you apply something.
Sorry. Yes.
Yeah. Our name was struck off from the records by exercising the power under rule 116 of the regulation. 1883. We are the pattadar of the land. Lordship is aware that it is a settled position that unless right is abandoned, the name cannot be struck. Unless I abandon my right, Bhavani Shankar Bagadia ki. Lordship is aware.
Why haven't you filed before the Board of Revenue?
Ashok, can we have a look at paragraph 5? Lordship is everywhere also. But just to define. Situated matter may not have referring the Calcutta Corporation case. In fact, what happened that the Inter Municipal Court, we pleaded the respondent number 5, but not file any affidavit in opposition. They using our land since last many years as a dumping ground. And therefore, taking into consideration of that, they said that we are out of position. So therefore, our name was struck up. So Lordship may appreciate, and my humble submission here, that without due process, if the state has acted upon, then Lordship has perhaps Lordship under the jurisdiction of either the statutory or the mandate. They are only Deputy Commissioner, respondent number 5 has filed the affidavit. 2, sorry, 5 is missing. Saying that since last 24 hours, the land has been used. So therefore, we have no interest about
Are you paying your taxes?
Yes, absolutely. We file everything. We file.
Where?
Page 25. All entire series of the revenue payment. In fact, we filed the patta and showing we are the patta there. Patta is the inclusion order was passed on 1/10/2000. Even the process for compensation, etc., matter would have been different.
Yes, government.
They were not in possession for 24 years, madam, when this order was passed, madam. And not
A person who is not in possession, you strike off the name.
madam, their objection were also called for, madam. As far as I agree, madam. Objection were called for, whether the
That's correct.
madam. We raised our objection. Subsequently, they submitted their reply also, but after considering all those things, my lord.
Let us read 116. Is there in page, not necessarily, page 39.
Maybe.
Yeah, 37. Whenever it comes to the notice of the deputy commissioner that any person whose name is recorded in the general register as proprietor, settlement holder, or manager of an asset is no longer in possession of any such interest in the asset, the deputy commissioner may
No longer is in possession of any such interest in the estate.
Yes.
Is not no longer in possession of the land. Any such interest in the estate. Interest means what?
Yes.
Means he has no form of any title to the land. Are you saying that merely because he is not in possession, can take it over?
any such interest in asset. Thus, they have interpreted my lord, because they are using as a dumping ground for 24 years, my lord.
If you have done it for dumping ground for 24 years or 100 years, can the state appropriate a property in this manner? Can there be a case of adverse possession by the state? Let us be knowledgeable. Cannot be an adverse possession by the state. The state has to take the recourse only by law.
That is why my lord objection was called for, my lord, that on the basis of objection. and
They
intent-
have it, therefore the order is before us. The face of it is beyond the jurisdiction. When they were paying the land revenue means they still have an interest. One. Secondly, the interest over the land is no longer there. This power is to be exercised. Just for example, in those pattas, somebody has already sold off, but sometimes their name still remains. So their name has to be struck off.
That
This
is
is the power you are to exercise.
my lord, because my lord, after my passing of this order, my lord, in 2018, they have not, my lord, corrected the land records, my lord.
Huh?
After passing of this order, my lord, in 2018, they have not corrected the land records, my lord. Maybe, my lord, that is why his name is still there, my lord, and he is paying the land revenue.
No, very well, very well. After passing off,
Passing of the 2018 order, my lord.
then
His name has not been, my lord, corrected, my lord, in the land record, my lord.
his name is there.
His name is there.
Very good. The name should remain as it is. But the fact that how do you exercise this power? This power is not to be exercised. You must have seen many of the cases where there are very categorically shown out there. Look at this person. Just for example, Mr. Bodotto has a plot of land of 2 bighas. He sells of these 2 bighas to you. But his name sometimes keeps on remaining there. Na? How do you strike off? This is the power which is being given in that Jamabandi or anything. How you have to have a power to strike off. The striking off is done under 116. That he does not is not in possession of any interest. When you go and show that look here, the entire land is being sold. If this power is not there, what happens? Always there is a problem. Just for example, tomorrow you have these 2 bighas. His name remains. You want to sell it to Mr. Roy. But what happens? You cannot sell because his name still remains. So you need this power to strike off his name. That look here, he had 2 bighas, he sold me these 2 bighas. So his name should be struck off. This is when you exercise 116. Isn't it? Mr. B. Dr. The learned counsel, senior counsel assisted by so-and-so, appearing on behalf of the petitioner, Mr. MCT appears on behalf of the state respondents. And anybody? Who is he? Mr. So-and-so appears for the respondent number 5. The petitioner hearing has by saying the order dated 1/10/2018 passed by the Deputy Commissioner in Sukia that is the respondent number 2, whereby in exercise of the powers under Rule 116 of the Assam Land and Revenue Regulations 1886, had struck off the name of the petitioner from the register of records in respect to tag numbers 12 and 13 of PT number 2 of
Button number 2, man.
2 number Patia Pakar village under Moza Tinsukia in the district of Tinsukia, Assam. The issue which has been raised in the instant proceeding is as to whether, merely because of the fact that the petitioner is not in possession of the land in question, the deputy commissioner can resort to the powers under Rule 106, Regulation 116 of the regulation. The materials on record categorically show that the petitioner is a company which owns a tea estate in the name and style of, what is the name?
Chupur.
Huh?
Chupur tea estate.
So and so.
SCWP was.
Pusto. The record further reveals that the petitioner have been duly making payment of the land revenue from time to time, as is evidence from Annexure 2 series. Be it as it may, and no notice was issued on 29, 2018, informing the petitioner that the land in question, land in question have been used by the respondent number 5 as a dumping ground. That have been used for the last many years. And as such, asking the petitioner to show cause as to why the powers under Rule 116, the Regulation 116 of the regulation should not be exercised. 27/8/2018, so-called notice. The petitioner thereupon submitted a reply dated 29/2018. Stating in earlier that the power under Regulation 116 cannot be exercised, of the regulation cannot be exercised in the facts and circumstances of the case, and accordingly requested the respondent number 2 to withdraw the said notice. Be it as it may, the impugn order was passed on 1/10/2018, whereby the petitioner's name was struck off in respect to the land in question. It is under such circumstances that the present petition has been filed.
You also pray, my lord, just pray for mandamus, for removing the breath. There, again. Worship kindly also.
In addition to that, the petitioner had also, but you have not asked for removal.
Worship.
You have not asked for, have you represented for removal?
Time and again, I'm not next hearing, but time and again.
No, in this petition, where is the document to show?
And the so-called notice also, we requested the.
That is to the deputy commissioner. You have not asked them for removal. Why should we exercise?
Worship may giving that liberty. Otherwise, we are.
In addition to that, the petitioner have also sought for a mandamus, directing the respondent number 5 to remove the dumping garbage from the land in question. It is seen that pursuant to various orders being passed by this court, an affidavit in opposition has been filed by the respondent number 2. Whereby it is seen more particular, whereby at paragraph number 6 of the said affidavit in opposition, it is mentioned that as the petitioner is not in possession of the land in question for the since 24 years, the power under Rule 116 was exercised. In addition to that, it has also been mentioned that the said land has been used, has been kept vacant for ancillary purpose. And there is a reference also being made to the provisions of the Assam Fixation of Ceiling on Land Holding Act 1956. This court have duly heard the learned counsel appearing on behalf of the petitioner as well as the learned counsel appearing on behalf of the respondents, and have given an anxious consideration. Before dealing with the impugned order, this court first would like to take note of Rule 100, Regulation 116 of the regulation, which is reproduced here in under. A perusal of the above quoted regulation would show that whenever it comes to the notice of the Deputy Commissioner that any person whose name is recorded in the general register as proprietor, settlement holder, or manager of an estate is no longer in possession of any such interest underlying in the estate. The Deputy Commissioner may order the name of such person to be struck off from the register. A reading of the above provision therefore shows that the exercise of the power can only be done when such person whose name is recorded in the general register as a proprietor, settlement holder, or a manager of an estate is no longer in possession of any such estate interest in the estate. The said expression used in Regulation 116 cannot, under any circumstances, be construed to be no longer in possession of the land in question. In this regard, this court have also taken note of a judgment of the court bench in the case of Bhavani Shankar Bagaria versus the State of Assam and others reported in 2008 for GLR 134. Paragraph 5 of the said judgment being relevant is reproduced here in under. In the backdrop of the above, if this court duly takes note of the impugned order, it would be seen that the emphasis so made by the learned Deputy Commissioner, that is the respondent number 2, is on the fact that the petitioner is not in possession of the land for the last 24 years, but without taking into consideration that the petitioner continues to hold an interest over the land in question and have also been duly paying the land revenue. In addition to that, the said land has also been permitted to be retained as per the Assam Fixation of Land Holding Act 1956 for ancillary purpose, as would be also seen from the affidavit so filed by the respondent number 2. Under such circumstances, it is the opinion of this court that the basis on which the impugned order has been passed is totally misconceived and erroneous, and accordingly, it is a fit case for interference. This court have also duly taken note of the submission of Mr. B. Dr. the Learned Senior Counsel appearing on behalf of the petitioner to the effect that there should be a direction issued to the respondent number 5 to remove the dumping, the garbage, to remove the garbage. Which one?
Or should we say it? It's a Hari Krishna Mandir Trust, paragraph 99, Super Mandama system.
Absolutely, I'm not issuing it. This court, however, duly takes note of that there is no materials placed before this court that the petitioners have represented before the respondent number 5, which is also a state within the meaning of Article 12 of the Constitution. It is an established principle of law that a mandamus can be only sought when in a case a justice is demanded and refused.
Giving us a liberty. Right.
Under such circumstances, this court, in the present set of facts, is not like to issue any mandamus for the reason that the petitioner had not sought for any, I have not requested the respondents, number 5, to vacate the area. Accordingly, the instant petition therefore stands disposed of with the following observations and directions. The impugned order dated 1/10/2018 passed by the respondent number 2, that is the Deputy Commissioner Tinsukia, whereby the land in question being this, the description to listen, was struck off and was reverted to the government of Assam, is held to be bad in law and accordingly set aside and quashed. Number 2, this court, as observed earlier, is not inclined to issue a mandamus on the ground that the petitioner have not represented before the respondent number 4, 5. Be that as it may, if the petitioner duly represents before the respondent number 5 and the respondent number 5 thereupon does not take any action, the petitioner would always be at liberty to exercise its rights under Article 300A of the Constitution. The above.
For orders, item 53.
Received by order dated 12/6/2023, this court had no issue notice upon the respondent by returnable under 4 weeks. But there is no specific directions as to how to issue notice upon the private respondent numbers 4 and 5. Taking into account that without the decision upon the respondent taking into account that there is no specific directions being issued in the order dated 12/6/2023. This court issues notice upon the respondent number 4 and 5, thereby directing the petitioner counsel to take steps, petitioners to take steps upon the said respondents by way of registered as well as usual within 7 days. As Bora appearing on behalf of the GMC submits that he requires some time to file an affidavit. This matter again on 12th of February 2025. Wait, what is this?
Lordship, this matter, Lordship, Council as Biswas appeared for respondent number 4 to 13, Lordship, very far away, but they did not file Wakalat Nama. Over.
So respondent number 3, 9, 10, 11, 13, and 14 steps is not complete.
Not.
The orders passed by the office note reveals that the steps upon the respondent numbers 3, 9, 10, 11, 13, and 14 is not complete. So the counsel for the petitioner is directed to take fresh steps upon the said respondents by way of registered post as well as usual within 7 days.
Interim is there, no confidence matter, interim is there. Kindly.
What interim? What meeting?
No confidence meeting, Lordship.
How can the no confidence meeting be state like this?
But Lordship.
Let us see this meeting.
Lordship.
How is this?
Lordship.
Tell me, what meeting you are challenging?
Lordship, I have challenged the requisition, Lordship, page 21, Lordship. This matter pertains to no confidence against the chairman of municipal board, Lordship. Act mandate this requisition shall be submitted before the chairman or vice chairman. It was submitted before the additional deputy commissioner, Lordship. It's not permissible under the act, Lordship. Subsequently, meeting was also held, Lordship, but no resolution was taken. Then they deferred the meeting. Deputy Commissioner.
Now you are the chairman.
I'm chairman.
You continue to be chairman.
Lordship. And in that meeting, 5 members were against me, Lordship, whereas 7 members are required, Lordship.
Yes, government, what do you have to say? Huh?
It was the chairman, but it is to the additional deputy commissioner.
What is he? Sir, this is regarding a no confidence against the chairperson. Chairperson, it will be to the vice chairperson.
To the vice chairman or chairman to hold the meeting for his meeting.
It cannot be sent to the chairman or chairman it should be given.
Yeah, it's the chairman. To prove your.
Huh?
It will be mandatory, Lordship, as per 23 subsection 2, Lordship.
And when is your period ending?
Lordship,
Huh? Period ending when?
27, Lordship. I was elected on 6/3/22, Lordship, 5 years term.
21/4. 5 years.
5 years.
Who is appearing for the other respondents?
Very far, Mr. S. Biswas appeared, Lordship.
And his submission is that he is filing ballot number, the ballot number has not been filed.
Mr. Roy, why are you not asking those people to return it? Pass an order that you see you cannot give it to us. Keep the thing, better we can finish it off. Why is it necessary? Mainly because yes, these people have sent the no objection to these people. You are therefore to instruct these people, kindly do one thing as per there are various judgments to the effect that the notice has to go to the particular concern out there, to the chairperson or to whatever may be, as per. So why don't you advise him? And with that advice, you return it. Once you return that we cannot hold it, his course of action is finished. Let us have it on 20, issue that letter then. List this matter on 20/12/2024. In the meantime, Mr. S.S. Roy, they appearing on behalf of the this Deputy Commissioner, na?
Gotcha. Additional deputy commissioner.
Appearing on behalf of the additional Deputy Commissioner, appearing on behalf of the respondent number 1 and 2. Respondent number 2 shall take any instructions. You just give that. Return it. Once that is returned, matter over. And as such, once you say that this you cannot do it, so nothing remains, then we close it.
Till then, Lordship, interim will continue, otherwise, Lordship.
Interim or this past solution continue to.
56.
Yes. Who appears? None appears on behalf of the CGST on call. Good stuff. This matter on Wednesday. It is observed that if the receipt none appears on behalf of the CGST, this court shall have no other option but to dismiss the review application for default. You have what? What is that? You are not filed a review.
The non-compliance of order at 28th of February 2024. Non-compliance of order at 28th February 2024. Lordship. The operative portion is page 13 and 14. Lordship.
What order is that?
As per that order, Lordship, the Director of Panchayat and Rural Development was directed to re-examine the matter, and if my claim is genuine, that he was directed to release my area entitlement, Lordship, bill amount within 2 months.
First, the Tamsir Singh verification is to be done. How can it be done within 2 months? Yes, Mr. Roy. How is it possible? Tamsir Singh, if Tamsir Singh is to be followed, then it has to be there as per it will go as per serially, chronology, properly. And how do you bring in this? Who appears for 1 and 3?
PNRD Lordship, as the earlier occasion Lordship, as the was appeared. He was
Okay,
directed
none
to
appears on behalf of the respondents when the matter is being called up. So for the ends of justice, the matter stands adjourned to be listed again on 22nd of January 2024. It is observed that if none appears on behalf of the respondents on the next day, this court would be compelled to issue the personal appearance of the contemnants in question.
58. May I please lordship, my lord, in this case on the last occasion. Mr. Sharma appeared on behalf of the respondent, my lord. He stated before the honorable court that review petition was filed. No status of review petition. Known to us, my lord, the matter is pending. Once today, his name was not shown in the cause list.
Whose name?
P. Sharma.
It has been seen that the name of Mr. P. Sharma, who appears on behalf of the respondents, has not been reflected. The registry shall list this matter immediately after the vacations, winter vacations, by reflecting the name of Mr. P. Sharma in the process.
Right. 59.
Their case, lordship, their name was not reflected in the court list, lordship. And the opposite party's name is not reflected in the court list, lordship.
Yeah, about to like report. It is further seen that the detail hetu nalage. It is to according order to it to decide it. This matter again on 22nd of January, taking into account that now the name of Mr. S. Dotto, who appears on behalf of the respondent numbers 1, 2, and 3, have not been reflected in the cost list.
59. May it please your lordship.
Yes, what is this?
My lord, this higher lordship, I have a limited clear lordship. Is page 7 lordship. Page 7 lordships. Paragraph, page 8 lordships. Lordships on the.
You are dismissed for default.
Lordships,
Why you have come? Order 9 rule 4, what is that?
null appears on behalf of the petitioners of all lordships. Otherwise, lordships, this petition disposed of on merit. Lordships prior to this lordship, 29/7/24, 3 dates were fixed. And accordingly, the under counsel for the petitioner appeared lordships. Now, my humble prayer, lordships, an opportunity may please be given for hearing this.
No, you have been asked to go to an appear before under 3H. I've not closed everything. I have asked you to go under 3H.
Lordships.
Go there. It is a question as to whether you are entitled or not. In not making payment of compensation in respect to the acquisition of land, NHRDCL has filed an affidavit was deposited to the affair of Ramesh Cooperative, the husband of the petitioner. Since the respondent has filed an affidavit stating entirely the compensation in respect to have already been paid to Ramesh Cooperative. The fact that the husband of the petitioner has received the compensation in respect to the land in question is a stand which has been taken. The petitioner herein could not show any independent right to claim any of the land in question, be that as it may, the question whether the petitioner would have an right or not. Go there under 3H. I have given you the liberty. You have to go before the district judge. Not before a district judge. 3H4.
Lordships, this IA is filed for all appears on behalf of the petitioners on all lordships. Whereas lordships, I also admit that the writ petition is disposed upon merit lordships.
So, either you have to file an appeal, but I have given you the liberty to go on the 3H because you see that the husband has already received the amount.
Received.
I could have very well waited out that made it dismissed for default, but the fact that it is not going to help you out, you have to go because the amount has already been received by your husband. So you have to go on the 3H. Mr. Ashome, appearing on behalf of the applicant, submits that the applicant would proceed in terms with the leave so granted by the order dated 29/7/2024 in the PPC number 3022/2023. So he, however, submits that taking into account that the instant application was filed, the period from the date from 29/7/2024 till date be excluded from the period of limitation. Taking into account the above submission, the instant application stands closed. However, the petitioner, the period from 29/7/2024 till date be excluded while computing the period of limitation for approaching the district judge. The civil court, the word used is approaching the court within the meaning of section 3H of the Act of 2019, National Highways Act 1996. I since closed.
60 and 61.
Yeah, please. You're dying.
When the project is directed to file affidavit, the status report is there.
Oh, yes, this one. What has happened here?
But the status report lordship investigation is on. And IO is yet to collect the report from the BDO. Is of 11/9, 7/11.
Now you have approached this court because they have not carried out any investigation. Now the fact that,
In fact, not the case was also not registered. Therefore,
honestly, now they have registered 2 cases after the order being passed by this court. 405 and
404.
where is 404?
That is in respect of item number 61.
Where is it?
That report was
One earlier reporting.
earlier.
Is there part of it.
404. Now 404 and 405 have been registered. We do one thing, as it has now been registered and investigation is going on, for us to look into it does not arise. If you are aggrieved, I give you the liberty to approach the authorities. If they, before that court, under now the present provision will be 173. BNS. What is the present provision? Huh? The BNS system. What if you are criminal experts within? Oh, hard Mr. So-and-so, the limit council. Mr. S.S. Roy, the limit council, if anyone. Charge of Poco Police Station. It seemed that pursuant to the orders being passed by this court, 2 cases have been registered, being Poco PS case number 404/2024 under section 120B /420, 468, 506 of the Indian Penal Code, and case number 405/2024 under section 120, 420, 468, 506 of the Indian Penal Code. So, taking into account that presently the investigating agencies are looking into it, and further the reports were submitted before this court by the investigating officer in charge of the Boko. This court would not further like to monitor the said investigation. Be that as it may, this court hopes and expects that the investigating authority shall investigate the same as per the permissible, as per the mandate of law, and complete the investigation at the earliest custom. It is further observed and directed that if the petition herein are in any manner aggrieved by the investigation, the manner in which the investigation has been carried out, to approach the concerned fictional magistrate for comes with section 170 Google BNSS 1 say. Where is that? You have come, you are criminal department. No. Hello, I am. Nagori. Contact the local. Report. ENSS. Nobody has a BNSS. Hmm.
Yes, sir. But my friend said 175. I think 179. Yeah. One 170.
With the above the instant proceedings, that's the score. The instructions so placed before this court dated 39/2024 and 7/11/2024 are kept on record in X, Y, I and Z respectively.
Against 63. Against 63.
Who is to file the
Yes, madam. The
amended
Response
memo
number
parties?
789 pollution, madam. They were supposed to file and they have in fact filed one affidavit today, madam.
Oh.
I have received the pollution
Ah.
as the status of the madam, pollution as regards the private respondents are concerned, madam. Perhaps this is not on record. 1612.
I've asked you to file a fresh memo parties. Why haven't you filed that?
Senior counsel,
Forget about your senior counsel. These were the specific direction upon the council to do that. Why haven't you done that? Counsel for the petitioners are directed to file an amended memo of parties before this court within 7 days. Why haven't you filed that?
another date.
Tomorrow we take it up. File your amended memo of parties. We take up day after tomorrow. Don't come up with this type of excuses. This matter on Wednesday. The counsel for the petitioner is directed to file the fresh memo of parties, amended memo of parties as ordered by this court dated 20/11/2024, positively by tomorrow. File it.
Publish. 64. Application lawsuit.
Service complete.
It's a demarcation matter. And private respondent, they have not appeared in spite of.
Service complete.
Yes, sir.
Service being complete leaves the matter for admission on 8th of January 2025.